specialized in business matters of the courts of Milan, Rome, and Naples. This brings several advantages, such as higher technical preparation of judges, faster decisions, uniformity of the case, at least on a trend basis, predictability of the decisions, and therefore legal certainty. Furthermore, the Italian system guarantees in a balanced way the rights of plaintiffs and defendants. This may be one of the reasons why it is not always appreciated. However, as a lawyer usually pleading on the defendant's side, I appreciate it a lot, and I think it is very well structured for ensuring an equal position of all the parties involved. At the same time, we cannot hide the fact that, notwithstanding the positive aspect that I have highlighted, some problems still exist. I make reference in particular to the rule entailing the obligation for Italian judges to change the section, chamber, and subject matter they deal with every 10 years. This is a point on which our first speaker, Marina Tavassi, whom I will introduce in a second, may say a lot of things on the basis of her unique and impressive experience. I'm sure she agrees on the fact that the rule at issue is rather illogical, especially in matters of high complexity such as competition law, and therefore it should be deeply revised. Special rules should apply to these special judges. As a more general remark, let me add that I have some perplexities on the current setting of the relationships between private and public enforcement of competition law in the European Union and consequently in Italy. Indeed, contrary to the United States, where private enforcement is a real alternative to public enforcement, in our system, private enforcement has been initially presented as an alternative to public enforcement, but has been subsequently developed as a cumulative tool which generally applies on top of public enforcement. In this respect, it is sufficient to note that no provision of the Damages Directive is expressly devoted to standalone actions, while the directive de facto encourages follow-on actions and protects public enforcement. As a result, European undertakings can bear a very heavy burden due to the combination of fines imposed by antitrust authorities and damages that may be compensated in private enforcement actions. A proposal that could be explored, albeit not resolving all the problems, is requesting antitrust authorities to consider, when quantifying sanctions, to take into account the possible amount of damages that the undertakings at issue may be called to compensate in the context of private enforcement. In any event, the accumulation of private and public enforcement also gives rise to an abnormal development of litigation funding, which leads to a distortion of judicial proceedings. Indeed, in some cases, lawyers lose their traditional role to become a sort of interested party, since they participate in the final result of lawsuits in a substantial way, also around 30%. I would like to add many other points, but I don't want to take up any more time to today's reflections. Therefore, I gladly leave the floor to Marina Tavassi, but since it is perhaps the first time that I chair a session in which Marina is a speaker, normally it happens the contrary, let me remind that Marina specialized, that Marina has been notably president of the Milan Court of Appeal, president of the chamber specialized in antitrust and IP matters of the Court of Milan, and judge at the Italian Supreme Court. She drafted the first judgment in Italy on private antitrust enforcement. She was also president of the European Association of Competition Law Judges and vice president of the Intellectual Property Judges Association. Professor of Industrial and Intellectual Property Law at the University of Pavia, and currently professor at the Master in Unitary Patent at the University of Milan, a university of which she is also a member of the board of directors. She is the coordinator of the technical table for the unitary patent, and since June 2014, she has been a member of the expert panel for the drafting of the rules of procedure of the European patent courts with unitary effects. Finally, I cannot avoid to remember that it's due to her hard work if in Italy we have 3 specialized courts competent for antitrust matters, with the advantages that I attempted to explain, and if Milan is now the seat not only of a local division, but also of one of the 3 central divisions of the Unified Patent Court. It is therefore actually an honor for me to chair this section. Marina, the floor is yours.
Thank you, Adriano, for this too long presentation regarding my position, and thank you for the perspective that you give us regarding the possible criticism of the Italian organization. I can say that now in this period, a group of professors, lawyers, and judges try to solve some of these problems, as for example, the necessity for the judge to change their position after 10 years in which they work for the specialized section. Everyone can understand that the specialization is very difficult to achieve, and that it is a great pity to annul this specialization in changing towards some other topic completely different. Now, sorry for the delay which we are starting our presentations, but today is a very critical day because there are a lot of strike, the rain, and some problem. We are ready to start. My presentation is dedicated to the multi-level governance framework, powers and responsibility of national judges. All of us are very informed, very well that antitrust protection is entrusted to different pillars that perform different functions. 2 pillars that are dedicated. The first, the public enforcement, is entrusted to the public authorities, including administrative judges, in Italy competent on the appeal against the National Competition Authority decisions, the Comp.Eu.Ter for the first instance, the Council of States, is second and last instance. Public enforcement is used to conduct investigations and where there is a violation to impose sanctions. On the contrary, private enforcement is up to the civil judges that are competent for action for compensation damages resulting from the antitrust violation, as Adriano told before. We usually distinguish antitrust actions into standalone actions and follow-on actions. The standalone action is when we have a decision before a trial before a judge without a previous decision of the National Competition Authority. On the contrary, follow-on action is when there is this, before the ordinary judge, there is a a trial after the decision of the National Competition Authority, named in Italy Autorità Garante della Concorrenza e del Mercato. Another possible distinction is between individual actions and collective action, for example, class actions. All these different types of action can be promoted by direct buyers and indirect buyers. Direct purchasers, purchasers of the subject that are author of illegal agreements, concerted practice or abuse of dominant position. Indirect purchaser, consumer or purchaser of the direct purchaser going down the distribution chain. Sorry, I have come back to make reference to the story, to the history of the creation of the antitrust culture with Regulation number 1 of 2003. This is part of the so-called modernization package, in which the Commission and the European Parliament decided that no more administrative act is required in order to avoid prohibition of restrictive agreements under Article 181, paragraph 3. Agreements satisfy specific conditions and effective cease their stipulation, and it is possible to invoke the so-called legal exemption by anyone interested in to do this exception without the necessity to have the previous notification to the Commission and to have an expressly or implicit exception pronounced by the Commission. Any statements in this regard can be made just in case of judiciary or administrative litigation. Limitation period shall be interrupted by this litigation, and withdrawal of the effective of a block exemption is possible to do by national authority. The monetization package comprises also the Commission notices of 2004. I love to make reference to these notices because they represent also nowadays a very important tools of help, tools to helping judges in solve some problems, some serious problems. They are also today very important piece of secondary level law. And I can mention the notice on cooperation within the network of competition authorities, cooperation between the Commission and the courts. For ordinary judges, it is very important tools. Handling of complaints by the Commission under Article 81 and 82 of the European Treaty in the previous version, and today Article 101 and 102 of the Treaty on the Functioning of the European Union. Informal guidance relating to novel questions concerning the same articles arising in individual cases, guideline on the effect of the trade concept between the member states, guideline on the application of this article. It is also important to mention the regulation number 773 of 2004 related to the conduct of proceeding by the Commission pursuant these articles. What are the changes determined by Regulation number 1? Before we have an implementation, a partial implementation by national authorities and judges, above all regarding the Article 81. After implementation of this article in full by the judges. Exemption before, exemption granted to the Commission using a paragraph 3 of, sorry, Sorry very much. And before we had a sort of monopoly by the Commission. Now we have a decentralized system. It is necessary to suspend by national authorities and court in order to wait the decision of the Commission, and that is not the case after regulation number 1. The regulation number 1 can represent a very milestone in the changing of this system. Sorry, I don't know what happened. I cannot close my tab. The effect, a real involvement of national judges and authority, and the reduction of commission burden. This is the most important effect. But we arrived at the directive of 2014, Directive 104. In this case, the Commission and the European Parliament decided that the decision of national competition authority or judges of appeal regarding this decision is deemed to be irrefutably established for the purpose of an action for damages brought before the national courts under Article 101 and 100 of the treaty or under national competition law. This is more than a privilege proof that is the first decision of the Supreme Court that I had the honor to write in that period, in which, before the implementation of the directive in Italy, we decided that the decision of the Commission and of the National Competition Authority can represent, in any case, a privilege proof. Just for decision of National Competition Authority of the same state of the judges is decided that this binding effect. No binding effect for National Competition Authority decision of other member states that can be only a prima facie evidence and is rebuttable for other means of evidence. But also this binding effect for national judges of the same state is limited because it is reserved only for positive decisions and not for negative one. Only those decisions applying Articles 101 and 102 of the treaty, not for other decisions made by National Competition Authority, and not in relation to the assessment of damage of causal link. These are the first duty that is on the shoulder of ordinary judges in the private force. Now what's happened? It's not possible to reach the volume.
Yeah.
Okay, thank you. The transposition of the directive into the Italian system was the occasion, the opportunity to decide some other choice. The territorial jurisdiction for the competition damage action has been brought before only 3 courts, 3 of first instance, 3 in appeal, specialized courts for enterprises in Milan for the north of Italy, Rome for the center and Sardinia, Naples for the south and Sicily. This is a very important step. This was a very important step in order to specialize the judges and to increase the quality of the decision. But in the same time, was the opportunity in which these judges were very, very busy because they had to decide all the cases in these parts of the Italian territories. And unfortunately, the Ministry of Justice didn't give other support to this court. No one man, no one woman, and no different support. And in the same time, in my opinion, with a completely unuseless decision, the legislative decree number 3 that transposed the directive in Italy, given for the judges this opportunity. The judges can ask the assistance of the National Competition Authority. The Italian National Competition Authority formulated specific requests on the guideline on the quantification of damages. Why I am so critical towards the decision? Because in my opinion, who is entitled, who has all the tools to decide in order to establish the quantification of judges is the civil judge, not the antitrust competition authority. That is an administrative body, very expert, very authoritative, but in a different field, not in the work, the job that is reserved to the judges. This consultation of the authority regarding the quantification of damages, in my opinion, remain without any serious effect. Also because in this phase, it is not possible for the parties, for the lawyers of the parties, to have an interlocutor debate with the authority. They are outside the authority, and the authority can give, could give to the judges this information. And we arrive to the topic of today, Digital Markets Act and Digital Service Act. Again, in this new piece of law, the Commission has centralized the role of itself in order to decide if there is a violation and so on. There is no space for national authorities except for a collaborative role towards the Commission. Why these choices? Why? Because undoubtedly the topic has cross-border characteristics inherent to the peculiarity of the digital system. Yesterday, also Professor Ginevra Bruzzone has given us this indication, and I agree. Once again, okay. What is the role of the judges, of the civil judges in these acts? There are no different roles assigned to the judges in the two regulations in comparison with those assigned by regulation number 1. This is the reason why we can refer to the regulation number 1 of 2003. The new regulations mirror the same limits to the role of judges that had been introduced by regulation number 1 for Commission decision and by Directive 104 for national competitions decision. I try to succeed. Okay, that's fair. Judge can use the investigation materials acquired by national competition authorities. They can use information elements useful for ascertaining the so-called distorting effect of the violation in order to assess damages and the causal link between the behavior and the damage. What could be the acquisition method, the spontaneous production of the parties and or requested by the judges? We have these specific articles in the Italian Civil Procedural Code that allow this possibility to us directly to administrative bodies, such as the National Competition Authority. The role of the Commission as amicus curiae. It is possible to obtain information or opinions by the Commission, and it is possible at Commission own initiative to present written observation to the judge or oral observation, but subject to the judge's authorization. This rule is also this possibility is also affirmed by Article 39 of the Digital Markets Act and Article 82, Paragraph 2 of the Digital Services Act. Relevant aspect for compensation of damages, the temporal scope, and we can use the Commission guideline specific of 13th June 2013, that is a specific communication on the quantification of damages, a Commission guideline of the 1st July of 2019, the communication from the Commission as guideline for national courts on how to estimate the share of overcharge which was passed on the indirect purchaser, the so-called passing on. What are the powers of the judges to grant compensation for damages, decided on claims for payment of contractual obligation, and a lot of possibility that is not possible for the authority. This is the specific role for the judges, even to adopt precautionary interim measures. Although I have to say that in the last year in Italy, the legislator introduced this possibility also for the antitrust authority, for the Italian antitrust authority. What is necessary for the assessment of the damages? The assessment is so-called ante deatur, using a Latin expression regarding the existence of the violation, the existence of the damages and the link of accusation, and the assessment of the quantity of these damages as loss of profit, actual damages, the so-called loss of chance, damage caused by loss of opportunities, and damage to the reputation, to the image of the subject. It is possible also to obtain also a liquidation inequity, but in the Italian system, only if you are the possibility to prove the existence of the damages, and it is impossible or extremely difficult to give the amount of these damages. Transfer of the overcharge, the passing on, compensation for the actual damages that could not extend, exceed the overcharge suffered without prejudice to the victim's right to claim compensation for lot of profit. This is the so-called the passing on, and if you want to delve deeper this point, you can read the guidelines that is in 2019. Once again, it's locked. Okay. The most crucial point in relation to the damage and its quantification is under the burden of proof. The directive established a relative presumption about the existence of the prejudice caused by a cartel, but it is only a rebuttable presumption, and the author of the infringement can overturn this presumption. The judges have to adopt the knowledge that competition law litigation is characterized by an information asymmetry, and they can solve the problem of the burden of proof using the proof proximity principle, which indicates that the burden to give the proof belongs to the person in possession of the proof. I finished my presentation. Thank you. This is the Aula Magna. Unfortunately, today is closed. This is the site in which is here, but they are refurbishing that period. This is the hall when we made the inauguration of the every year of the judicial year. And this is my task, was my task for the month of January every year, and now of my successor. Thank you for your attention.
Thank you, Marina, for this rich presentation, which I found extremely useful to take stock of the role of national judges in the new current competition law framework and behind. You mentioned the binding effect of Commission decision. And in this respect, I wish to remind that according to some distinguished authors, this binding effect is in contrast with the fundamental principle of our Constitution, and that the binding effect of the Commission decision will be discussed soon before the Court of Cassation. The other point that you touched is the fact that the three specialized courts that, thanks also to you, we have now in our legal system have not sufficient resources, starting from the judges, for working properly. I must mention that just in these days, in this building, in a hearing, the judge of the specialized section in this respect suggested us lawyers to do something with the politicians in order to solve these problems. But I think that it is not up to lawyers, but it should be up to the lawyers and to the judges to do it together, because otherwise we don't have an advantage, but a problem in these new three curves. So thank you again very much. It is now time to move to the second topic that will be tackled in our session. The most relevant private international law aspects of private antitrust enforcement, with particular attention to digital markets. On this point, before leaving the floor to our second speaker, let me just mention a trend that we are noticing in the practice of private antitrust enforcement. The gradual increase in the number of actions brought before the courts of some specific member states of the European Union rather than others. I'm thinking in particular of the Netherlands and Spain, where the number of pending cases is really enormous, much higher than the one of many other member states. Is this a coincidence? Of course not. Some member states are doing, so to say, whatever they can to encourage the alleged victims of antitrust infringements to bring cases before their courts. Clearly, the rules on jurisdiction allow for some forms of flexibility, as will be shown by Alberto Miglio in his presentation. However, I see a serious risk of forum shopping and instrumental conducts on the part of the plaintiffs. If we consider that this trend is completed by the practice of assignment of claims, which is becoming a huge business throughout the European Union, we understand how far we risk to be from the objectives set out by the same European legislator in the Damages Directive. One of the aims at the basis of the adoption of such a directive was indeed, as clarified by its 9 recital, to increase legal certainty and to reduce the differences between the member states as to national rules governing action for damages for infringement of competition law. An approximation of those rules will help to prevent the increase of differences between the member states' rules governing actions for damages in competition cases. I turn immediately to Alberto Miglio, whose presentation is entitled Private Enforcement of Competition Law and Digital Markets, Issues of Jurisdiction and Applicable Law. Alberto is assistant professor at University of Turin He holds an LLM from the College of Europe, Bruges, and a PhD from the University of Milan Bicocca. And according to my information, he is also qualified for performing the function of associate professor. So, Alberto, please, you have the floor.
Thank you, Mr. Chairman, for this good kind introduction. And it's, of course, a great pleasure to be speaking among such distinguished panelists and to such a qualified audience. And in fact, I feel a bit like an imposter because I think I'm the only person in the room who is not really a specialized competition law expert. So we'll try to bring to you a slightly different perspective, that is private international law. And my aim is to convince you, persuade you that private international law issues are important and must be part of the backpack of a judge dealing with competition law issues. That is obviously because, as our chair mentioned, competition law leads to a lot of cross-border cases, and this trend is of course increased by digital transactions and by the digital markets, which are the focus of yesterday's and today's workings. I will be touching upon 4 issues, which means there's a lot of time leaving aside, and I'm not even sure that in the about 20 minutes that I have, or maybe a little less, I will be able to cover those 4 issues in detail. So if I don't, I will still close in 20 minutes at maximum and leave the rest to my presentation, which will be shared with the participants, and also to the paper, which will be published in a few months, along with the other proceedings of the conference in a book, and also open access, so we will be able to also share it with your colleagues. So the 4 issues that I'm going to touch upon are characterization or classification of claims, as you may, as you can call it. That is essentially distinguishing between issues of contract and of tort law. Second, I will briefly touch upon court jurisdiction under Article 7.2 of the Brussels 1bis regulation. Then move to the law applicable to competition law infringements, and finally say a few words about the relationship between the DMA and private international law. Now, starting with characterization of claims, it's obviously a crucial issue because different criteria exist for jurisdiction depending on whether you are dealing with matters relating to a contract or matters relating to tort, delict, or quasi-delict. And obviously, this is also a crucial issue for applicable law because we even have the different instruments, different legal instruments dealing with the determination of the law applicable to contractual obligations, Rome 1, or to non-contractual obligations, Rome 2. And it would appear quite straightforward that all competition law claims are non-contractual, but in fact, the dividing line between 2 categories of claims is probably much more nuanced. This has been a contentious issue in the case law of the Court of Justice, at least since the mid-1980s, but I will make reference only to some of the most recent judgments, which you see quoted here. In particular, I will be dealing a bit more specifically with the Wikingerhof case, which relates to classic digital markets issues. Wikingerhof, the case decided in late 2020 by the Court of Justice of the European Union. It arose from a reference for a preliminary ruling issued by the German Supreme Court, the Bundesgerichtshof. The underlying case related to a dispute between the German hotel, Wikingerhof, and the booking platform for the delight of Daniel. So we're really at the heart of digital markets, and not surprisingly, the case also gave rise to a lot of classic digital markets competition law issues, because Wikingerhof was claiming that some contractual terms inserted in the service contract constituted an abuse of dominance. For instance, one of the issues was whether the rate of the fee of the commission that the hotel was paying to the platform was for even if not results was as an example of an abusive dominant position. And the remedy that Wikingerhoff claimed was injunctive relief. So it was claiming, was seeking from the court an injunction preventing Dulking from enforcing those terms. The first instance court found that it had no jurisdiction because it considered that the jurisdiction clause included in the contract was valid. On appeal, the Oberlandesgericht Schleswig took a different view on that and considered the clause invalid, but then it found that it had no jurisdiction nevertheless, because it qualified the issue as contractual, and therefore under the Brussels 1 bis regulation, jurisdiction would lay with Dutch courts. The case went to the German Supreme Court, which did not share the view of the Court of Appeal, and then referred the question to the Court of Justice in Luxembourg. The court first recalled its holding in the Pogzita case 2 years earlier, that, and I quote here, an action concerns matters relating to a contract if the interpretation of the contract appears indispensable to establish the lawfulness of the conduct that is complained of. It's very complex and unclear formula. I guess judges might have some difficulties applying it. And then in Wikingerhoff, the court added that where the applicant relies on rules of liability in tort, presumably it's a claim based on competition law, and where it does not appear indispensable to examine the content of the contract in order to assess whether the conduct is lawful or unlawful, since the obligation applies to the defendant independently of that contract, statutory nature of the source of the obligation, then the cause of the action is a matter relating to tort. End of quote. So the issue seemed relatively settled. Then 1 year later, the Court of Justice issued another case which did not relate to competition law issues. It was a case on unjust enrichment, where it recalled in its entirety the Wikingerhoff formula, but then it added, however, a claim for restitution based on unjust enrichment may, in certain circumstances, be closely related to a contractual relationship between the parties to the dispute, and consequently be regarded as coming within matters relating to a contract. Thus, these circumstances include the situation in which the claim relates to a pre-existing contractual relationship between the parties. And you wonder whether this is a specification or an exception to the Wikingerhoff rule, and you also may wonder whether or not it applies beyond unjust enrichment, and my guess would be, why not? I mean, why would you have an exception that is only there for unjust enrichment and not for claims? But the court never said that. So let's try to conclude on the characterization of claims. Cartel damages claims are clearly non-contract. It's not case law on that. That's non-contentious. In a judgment, Fly-Lal Lithuanian, this is the second judgment, so I called it here Fly-Lal 2. You see the case number as well. The court seemed to imply that all abuses of dominance are matters related to tort. But then if you look at Wikingerhoff and you apply the Wikingerhoff and also the subsequent case, you probably end up with a much more nuanced test. For exclusionary abuses, as was the case in Fly-Lal, then there's also pretty much no question that would be non-contractual issues, also because typically the actions are brought by competitors, not by contractual partners. For exploitative abuses, I would say arguably in light of Pogzita and Wikingerhoff, the characterization is also non-contractual because of the source of the obligation, it is statutory, and because contract interpretation might be involved, but it's likely not indispensable to establish whether the lawfulness, whether the conduct was lawful. It will mostly just be a preliminary issue. But then if you look at this Watzke-Schume case, I hope I'm not butchering the case name, you might end up with a different answer, because here you have claims that are apparently connected to a pre-existing contractual relationship, so which might have that certain connection with the contract that would, again, by way of exception, have the issue fall into Article 7.1, so contractual matters. Cases of refusal to supply, here again, probably Generally, the answer is they're non-contractual because of the source of the obligation of the statutory, same issue as in the previous case. Disputes on the legality of a termination of a contract are probably more trickier to classify, because if you apply the Tavassi-Schumer case, here really you have an issue that refers to a pre-existing contractual relationship. So there's room to argue that this might be contractual. And then we might also ask ourselves, what if in a case like Vikingapov, the claim had not been for injunctive relief, but for contractual nullity, for had been an action seeking a judgment asserting that the contract was void, then in that case, would that have changed the characterization of claims or not? There's a lot of discussion in scholarship about that. So you may excuse poor judges for being a bit lost in that case law, but unfortunately have no final answers apart from those few hypotheses that I made. And let's move therefore to tort jurisdiction. Here the rule that we have to start from is Article 7, Paragraph 2 of the Brussels 1 bis regulation, which provides for the jurisdiction of the courts for the place where the harmful event occurred or may occur. And as you may be aware, in fact, this formula refers to two different places. The place of the event giving rise to damage, we also called the causal event, and the place where the damage is suffered. Please note that damage with reference to this provision only refers to initial damage, not what the court calls mere adverse consequences, although it interpreted the notion of initial damage rather liberally. The existence of two different fora, two different places under the Article 7.2 formula means that there are alternative fora available to the plaintiff, and they also, and to that we also have to add the general forum of the defendant's domicile. The problem here is that both the place of causal event and the place of damage are not determined according to a one-size-fits-all approach, but they have to be assessed on a case-by-case basis and may differ for different types of infringements, including of competition law infringements. In relation to cartel cases, the court developed a three-step test in the CDC hydrogen peroxide case in 2015. If it is possible to ascertain that if there is a single place of conclusion of cartel that can be identified, then the courts of that place will have jurisdiction over all cartel participants and for all of the damage. If that is not possible because the cartel consists of a series of collusive agreements concluded in different places, then the court should ask itself whether there is one agreement among those which is the sole cause of the event giving rise to the damage in relation to a particular victim. And if that is the case, then that court and the court of that place will have jurisdiction over all the cartel participants, but solely for the loss suffered by that victim. So you already see here concentration of claims is not always entirely possible. If the loss is not exclusively caused by one agreement among those that form part of the cartel, then it's simply impossible to establish where the causal event took place, and therefore special jurisdiction under Article 7.2 can only be based on the place where the damage occurred. If we are dealing with abuses of dominance, then the place of the causal event has to be determined differently, obviously, because we had no agreement. That was an issue in Flylal 2, where it was unclear whether a certain predatory pricing practice would fall under Article 101 or Article 102. So the court also dealt with the interpretation of Article 7.2 of the Brussels 1 bis regulation in relation to uses of dominance, and it came up with this formula. The event giving rise to the damage in cases of abuse of dominance is based on the implementation of the abuse, which means that you have to look where the acts performed by the dominant have been taken to put the abuse into practice took place. And so jurisdiction lays with the courts of the place where the anti-competitive conduct was implemented. And here again, might be an issue to decide where it mainly was implemented to establish the forum. the broad form. What about the place of damage? In cartel cases, this is again a quote from CDC hydrogen peroxide. The court identified the place of damage in generally, but there might be exceptions therefore, in the victim's registered office. Of course, this criterion works differently for each victim, which means that concentration of claims is possible against all cartel participants, but only in relation to the damage suffered by a particular victim, which means that different victims having the registered offices in different places must each sue in the place of the respective registered. This approach is also confirmed by more recent case law, notably in the Volvo case in 2021. There are also some cases in between where the court also introduces some more clear reference to market affectation, and it's not very clear to me really how that overlaps or interacts with the previous criterion, where the market affected by the anti-competitive conduct is in the member state in whose territory the alleged damage is purported to have occurred. That member state must be regarded as the place where the damage occurred. So, in conclusion, on jurisdiction, as our chair already mentioned, a plurality of alternative fora. Sometimes concentration of claims is possible, sometimes it's not always possible. This obviously, presence of a plurality of fora obviously entails the risk of forum shopping. The risk is also exacerbated by the possibility of suing multiple defendants in the place where one of them is domiciled, if the claims are connected, and if there is a risk of conflicting judgments, if concentration of claims does not happen, if the proceedings are held separately in different jurisdictions, Article 8.1 of the Process 1bis regulation. In some cases where there's an underlying contract, then this risk can be mitigated through exclusive jurisdiction agreements, and you can think of the Wikingerhof case scenario if the jurisdiction clause had been valid. So overall, our chair is certainly right that the Court of Justice has followed a plaintiff-friendly approach to jurisdiction and has helped creating a lot of plaintiffs' fora. One may wonder why, and my hypothesis, which is also discussed among scholars, is that the court is really extending to the jurisdiction rules, to the interpretation of the jurisdiction rules, the famous courage logic of encouraging target enforcement of competition law. This is some drawbacks, but it's also there to stimulate private enforcement. Law applicable to competition law infringements. Here you have a special rule in Rome 2, in the Rome 2 regulation. It's Article 6.3, which applies a criterion of market affectation. I will not repeat the rule which you see here on the slide, but I want to point out three issues. Now, the first is that courts, that may be a bit unusual for a judge, but it makes sense in this case. The need to assess prima facie the affected market at a very early stage of the proceedings. So just in order to determine what the applicable law is. The second issue is what is meant by restriction of competition. Here there's a recital in the regulation clarifying that this formula refers to the types of conduct prohibited by Articles 101, 102 TFEU. And that, of course, leaves a loophole because what about, for instance, the DMA? So are DMA obligations and prohibitions also covered by this provision, or what is the criterion for determining the applicable law to wishes that are not regulated in the DMA itself in those cases? And then you also have an issue when more than one national market are affected, especially when you have a competition law infringement that affects the whole internal market. Then in theory, you would have to apply the law of each country where the market is affected. That is obviously not very practical. So at least in one case, you have a way out, which is the provision in letter B of Article 6.3. When the market is affected in more than one country, the person seeking compensation, if the lawsuit is brought in the place where one of the defendants is domiciled, then the plaintiff may choose to base the claim solely on foreign law, which simplifies matters a lot for the national courts, provided that the market in that member state is among those substantially and directly affected by the restriction. Lastly, just a couple of words on the relationship between the DMA and private international law. And there's not really much to say here because this relationship is still to a large extent lacking. Let's say unilateral conflict rule in the DMA, which resembles those existing in the GDPR, which was a blueprint for this type of clauses, and in the DSA, so a rule that delimits the scope of the provision. You see it here, it won't read it aloud. But there are no real rules on jurisdiction or on the law applicable to issues that are not harmonized in the DMA itself. So there's still a need, even there, to coordinate the DMA with the Brussels 1 bis regulation to establish jurisdiction, and with the Rome 1 for contractual law aspects, and with the Rome 2 regulations. I'm sorry, you have very few answers and a lot of doubts and obscurity for judges, but I mean, that's the state of the law, unfortunately, and I thank you for the floor.
Thank you, Alberto, for your interesting report and for your reflections on those that I have always considered complex and highly technical matters, which at the same time have very significant implications in practice, as already mentioned. The concentration of the claims against one only of the cartelists that you mentioned, in our experience, doesn't work, at least in cartels, which are not very simple cartels. Indeed, they would result in a problem for the defense of the defendants, in particular when the products are not completely equivalent, if the sales network of the different cartelists are different, and if the technicalities of the products are a lot. Indeed, what's happened in these cases? In these cases, the defendant calls the other cartelist in the lawsuit, and if the judge does not grant the possibility to the defendant to call the other cartelist in the lawsuit, the other cartelist will intervene in the lawsuit, and therefore this is a problem which is causing a lot of to render longer the lawsuit. The third and last picture will focus on non-economic objectives under Article 101 of the treaty. This is a very topical issue in the current competition law debate. I can mention in this respect the fact that the last Congress of Fédération Internationale pour le Droit Européen, held in Sofia at the end of May of this year, was focused inter alia on this topic. At the institutional level, much has been said about this issue in the context of the revision of Commission's guidelines on the applicability of Article 101 to horizontal cooperation agreements. We are all familiar with the word sustainability, which is becoming a recurring concept in many fields of our lives. We know that it does not only refer to environment, but more generally, there are important aspects of sustainability in the social and economic areas. What is interesting is how much sustainability is becoming a relevant issue in competition law, both in theoretical and in practical terms. These and other aspects will be tackled by our third speaker, Maria Campo Comba. She is Assistant Professor of European Union Law at Erasmus University of Rotterdam. She holds a PhD from the University of Groningen in the Netherlands, an LLM from the same university, and the law's bachelor's degree from the University of Santiago de Compostela in Spain. Maria, the floor is yours.
Yes, thank you so much. Thank you to the organizers for having me here. And I am very honored to be sharing, be part of this panel with these such experts. And it was very well introduced, the topic I will be talking about today is non-economic objectives under Article 101 of the treaty and recent trends. And as you will see, this presentation may fall somehow within or out the limits and the scope of this conference. But the presentation is also about the limits and the scope of competition law. During the last years, these major societal challenges have revived this never-ending debate in which competition experts aim to answer what is competition law all about and whether and how competition law should face those new difficulties. And two of these major challenges are high in the EU agenda as well as in the globalized agenda, and they are the digitalization challenge and also the sustainability challenge. And these challenges have also made it to the forefront of the competition law agenda in the EU. And they make us question what is the role of our legal discipline here when it comes to digitalization and sustainable development as modern market challenges, but also as modern societal challenges. And we know the consumer welfare approach, this more economic approach to EU competition law of the last 2 decades might not be completely suitable to face these challenges. And this is what many of our colleagues are trying to answer. As some background introductory notes also, we sometimes talk about competition law as a sword and as a shield. And it is generally understood that competition law can be used as a sword or as a shield. Non-economic goals and considerations, which for the sake of this presentation, we can think of as public policy, public interest. So non-economic goals and considerations may be used as a sword, and reinforcing competition law enforcement to fight against behavior that harms non-competition interests, and that will be within the Article 102, and maybe reinforcing or making competition law enforcement more strict. However, this presentation focuses on Article 101 and competition law as a shield. And it tries to answer whether non-competition goals and considerations may be used as a shield, and allowing for certain otherwise prohibited agreements when these agreements are beneficial to pursue these non-economic goals. This leads us to the question, to which extent are non-economic objectives considered in the assessment of anti-competitiveness of an agreement between undertakings. And to answer this in this presentation, first, I will give a very short overview of the competition law approach to non-economic objectives. Then I will go to recent developments on Article 101 and collective labor agreements. And this is specifically referring to digital platform workers' rights, so the new guidelines there. And third, recent developments on Article 101 sustainability objectives and the new guidelines, the new horizontal guidelines that include a chapter on sustainability agreements, and I will talk a bit about that. As a spoiler for this presentation, I focus on the recent developments brought by the Commission. So there would not be that much case law, or at least case law that you are not aware. So the case law I mentioned, you are all very aware from it, I think, but it's more focused on these new developments that the Commission brings. And the idea of it was to see if there is a changing in the trends and based on these new guidelines. So first, very short, an overview of the competition law approach to non-economic objectives. As we know, before the modernization and economization of competition law in the EU, I wanted to make two highlights. We had the Metro 1 case with the workable competition standards, saying that competition, or we should ensure workable competition as the competition necessary to ensure the observance of the basic requirements and the attainment of the objectives of the treaty. Also, according to the empirical findings of our colleague Brook in her comprehensive empirical study of the consideration of non-economic interests, Article 101, the Commission took even broader types of benefits than those provided for by the case law, and not putting a limit to the types of benefits that could be considered under Article 101(3). So the Commission was assessing both economic and non-economic benefits that benefit individual consumers, but also society as a whole. And she gives some case examples in her book. But then after modernization and economization, we have focused, or the Commission has focused on consumer welfare and this more economic approach. And as highlights here, I use the Commission guidelines on Article 101(3) of 2004, saying that non-economic benefits should only be taken into account if they are goals pursued by other treaty provisions, but only to the extent that they can be subsumed under the 4 conditions of the article. And these conditions were interpreted quite restrictively. And we could notice a change in the terminology because these conditions were being referred to by the Commission as objective economic efficiencies to be calculated. In contrast, the courts of justice never fully clarified this, but there was reference to non-economic benefits. I will mention this later on as well. But we also see the difference in the terminology used by the Commission and the courts in these cases, which the court was still referring to objective advantages that should be examined. In the last years, the Commission rhetoric is changing, and we have seen that we enter into this fairness mantra of Commissioner Vestager, and she has in numerous occasions emphasized the importance of fairness in competition law. I quoted here one of her speeches saying that protecting competition is about efficiency, but not only. Fundamentally, it is a question of fairness. What is fairness? How do we apply fairness? How do we interpret fairness? In competition law, what does it entail? And there can be multiple perspectives and recipients of fairness in our field. It can be the creation of a level playing field, making the process of competition fair. So providing the same initial opportunities to firms in the marketplace and protecting the structure of the market. The DMA seems to go in that direction. But fairness has also been argued by some authors that it shouldn't entail fairness exposed, meaning equality of outcomes. Or even that fairness could also entail all socially desirable objectives that can fall under the competition policy regulatory agenda. So it can go as far as we want it to go. But beyond the rhetoric and the potential political meaning of fairness, or the fairness mantra, recently emphasized by the Commission, there are possible examples of fairness in the current competition law practice, and one was this the DMA and this level playing field. But we also have the fair share requirement in Article 101(3). which, as I will explain later, still seems to be related to the maximization of consumer surplus rather than to any broader meaning. But let's see I will go now to the specific developments and see if we actually see a change of direction here. The first development here is regarding digital platform workers' rights. So the platform economy has notably increased the number of atypical forms of employment, from the very well-known delivery riders or ride-hailing services to even domestic workers. Delivery food, Uber, domestic workers platforms, and so on. The labor rights of these workers have been discussed for many years, and many member states have already took action. And in competition law, this takes us to the Article 101 exception regarding collective labor agreements. While on the one hand we have the labor law perspective, and we have the right to collective bargaining for workers as fundamental rights, and this is in all these instruments I mentioned here, you can see in the slide. And in the EU, this right is protected by Article 28 of the Charter. On the other hand, we have Article 101 that prohibits agreements between undertakings. And of course, there was a clash here. That's why the court has developed some time ago already an exception for this. So workers could actually enter into labor agreements without fearing competition law. I mentioned the famous Albany judgment, and in Albany, the court said that the agreement will fall outside Article 101 if it is conducted in the context of collective bargaining between employers and employees or the representatives, and if it's aimed directly at improving the working terms and conditions of employees, then this would not be considered an agreement between undertakings. Then also in V. Custom, the court held that insofar as an organization representing workers carries out negotiations acting in the name or on behalf of those self-employed persons who are its members, it does not act as a trade union association and therefore as a social partner, but in reality acts as an association of undertakings. And according to the court, the exception was not extended to self-employed individuals because the treaty did not contain provisions that encourage self-employed service providers to bargain with the employers to which they provide services. But later on, well, it was the court also developed the exception for the false self-employed, and this is to say service providers in a situation comparable to employees. However, this exception requires a case-by-case analysis, and it was not so clear whether this could include these atypical workers, these platform workers. And this leads us to the recent development on this, because after some time of not knowing exactly how this could fall within the exception, and especially with the COVID-19 pandemic, we saw the increase of this kind of employment, and the continuous growth of these digital platforms. Some need for certainty was there. And the Commission published in September of 2022 the guidelines on the application of union competition law to collective agreements regarding the working conditions of solo self-employed persons. Here, what is relevant for this presentation is that the guidelines clarify when collective labor agreements between solo self-employed persons and one or several undertakings fall under the article, and they include the definition of solo self-employed persons working through digital labor platforms. And here, emphasis is placed on the role of the online platform in organizing the work performed by individuals at the request of the recipient of the service provided by the platform, but it does not cover online platforms that merely provide how the service providers can reach the end user. For example, the definition of digital labor platform will cover a service such as ride-hailing platforms, Uber, for which the organization of work performed by the drivers is essential. But if the digital platform merely gathers and displays the details of plumbers available in the area, just allowing customers to contact them, this does not fall under the definition and thus does not fall under the exception. Yes, and then finally, as it can be observed, the court previously the social policy objectives of the EU into account in its ruling in Albany and the following rulings, providing for an exception of Article 101 of the treaty on basis of those social policy objectives. And in the same manner, the Commission recognizes in the new guidelines the reference to these rights. So the guidelines make reference to these articles, Article 3, Paragraph 3, Article 9, 152, and so on. These are the relevant articles for competitive social market economy that ensures full employment, ensure collective bargaining, and so on. For time's sake, I won't enter into the other possible paths, but I will make reference to it at the end. Other possible paths that are outside this recommended path by the Commission. So the last part of the presentation goes to the recent developments on sustainability objectives, and let's see if we have some similarities between these two developments. As you know, the sustainability challenge is one of the main challenges that our world is facing, and of course, competition law could not be left out of the debate. And the debate focuses on the extent to which these uncompetitive about the anti-competitive effects of sustainability agreements could be allowed if the agreement brings some sustainability benefits. As I mentioned, the relevant treaty articles in the case of labor agreements, I also wanted to do it in the case of sustainability, highlighting that we also have very relevant public policy objectives here in the Charter of Fundamental Rights, but also in our treaties, and that they ensure that all the policies of that are in the treaty should work with each other, short words, and then the others also highlight the importance of sustainable development in the EU, and that other policies such as competition policy could also work together with this. As a background note, as we know, the 2004 guidelines and then the previous horizontal guidelines, they had a restrictive interpretation of Article 101, Paragraph 3. The 2011 not even mentioning sustainability agreements, and then emphasizing objective economic efficiencies in a restrictive manner. However, in the last decade, we have seen increasing concerns coming from national competition authorities. The Dutch competition authority was there pushing for it, also the Greek one, but also academics pushing to consider sustainability objectives. And the problem was how. So finally, the Commission took action and gave us some clarity and certainty on how should we proceed with this. And just in July 2023, the Commission adopted the new revised horizontal guidelines, and Chapter 9 is a chapter on sustainability agreements, and clarifies how these agreements can be allowed under Article 101(3) and therefore not be declared anti-competitive. First, I want to repeat that the definition of sustainability is a broad one. So it entails environmental, but also social and economic objectives. For example, if we check the Sustainable Development Guidelines, we can see that the improvement of data privacy conditions can also fall within this definition of sustainability. So it's as broad as that, also human rights. So relevant for many fields. And now I want to enter into the specifics of the guidelines to summarize. In the case that sustainability agreements are not standardization agreements, that will have some specific guidelines as well. There is a detailed, a need for a detailed assessment under Article 101(3) when it comes to the measurement of efficiency gains and fair share to consumers, unless it is obvious. I will only mention these two conditions, but as you know, we have 4 conditions in this article. For this assessment, the Commission distinguishes between agreements involving individual use value benefits, individual non-use value benefits, and agreements bringing collective benefits. Those that are individual non-use value, or individual use value benefits are those typically deriving from the consumption and the use of the products by the consumer. So not by chance, but this agreement brings sustainability benefits, but also brings other benefits, and it will have been anyway exempted under Article 101(3). So we don't have anything special here. What is important is the other two. The individual non-use value benefits are considered indirect benefits, which result from the consumer's appreciation of the impact of their sustainable consumption on others. And they are to be measured by a willingness to pay method. So only if the parties to the agreement can demonstrate that consumers are willing to pay for the sustainable improvement, then we can move on with the analysis. The problem here is, we need to determine, will consumers be willing to pay for the price increase, for example? So in the, let's put an example, the typical chicken of tomorrow in the Netherlands. In that case, they wanted to improve animal welfare conditions for the chickens in farms. And there was an agreement, or they wanted to conclude an agreement between the supermarkets, but the chicken farms to improve animal welfare conditions. So the chickens will have more space, more lights, a nicer life for us. What will this mean? That consumers in the supermarket will have more expensive chicken. Here, and well, the analysis back in the day by the ACM was similar, but now under these new guidelines, we will have to conduct a willingness to pay analysis. So not we, and not judges, but the parties of the agreement. The problem of this willingness to pay analysis, the problems that we know. It depends how we conduct this analysis, then this will affect the results, bounded rationality of consumers, difficulties to measure some sustainability. For example, how do you measure intergenerational equity, potential biases, lack of information, and so on. So all the problems that come with the willingness to pay analysis. And in addition, also to note that the consumer sustainability preferences when acting as a consumer may be different than when they are acting as citizens. For example, I might be the most green citizen when I vote and execute my rights. But as a consumer, maybe I prefer the cheapest product in the supermarket because of my rationality in this case. Anyway, moving on from these problems of the willingness to pay. This is what the Commission advises in the case of these agreements. And finally, they also recognize when it comes to the fair share requirement, they consider an exception concerning collective benefits. And these are the benefits that will affect a larger group of society, irrespectively of the consumer's individual appreciation. So here, they mentioned that the sustainability agreement can be used to internalize the negative externalities of individual and sustainable consumption. and bring about sustainability benefits to a larger group of the society. Here we can think about environmental damage agreements, such as those concerning emissions or phasing out polluting technology. While the balancing of benefits with negative effects resulting from the agreements is normally conducted within the relevant market, the Commission states that where two markets are related here, the efficiencies achieved on the separate markets can be taken into account, but provided that the group of consumers affected by the restriction and benefit from the efficiency gains is substantially the same. So it goes a bit broader than the restrictive interpretation we had before, but not so much. So, for example, in this case, an agreement that reduces the use of fertilizers and water in the products used for dyeing clothing in factories located in the EU could likely bring collective benefits, because it's likely that there is a substantial overlap of the consumers of this clothing in the EU and the beneficiaries of these agreements that are also located here in the same area, and we have cleaner air and a more efficient use of water, let's say. It will be different if these benefits will occur in another part of the world, but I will not enter into that debate. Well, in conclusion, while the Commission recognizes the importance of pursuing sustainability objectives in the EU, it does not grant a real exemption, or but it clarifies the way of how can we interpret them. There are other two routes. I will mention them very fast. Outside of Article 103 and outside of the guidelines, I think most of us are aware of them. The Albany route that I just explained, with the Albany case and pursuing treaty social policy objectives, and also the Wouters case exception, that here the court provided an exemption on the basis of pursuing legitimate objectives of domestic public policy. For time's sake, I won't enter into the details, but let's say that this case maybe could be used mutatis mutandis for also sustainability objectives, since it was already pursues legitimate objectives of public policy. Quickly conclude. We have seen two recent developments by the Commission regarding non-economic objectives and Article 101, both in these guidelines. Here my personal reflection is that the treaty provides for the consistency between its policies and activities, taking all these objectives into account, which seems to be considered regarding social policy objectives, and in the case of employment and collective bargaining, but does not seem to meet the same mark when considered other EU policy objectives concerning sustainable development, also because it's more difficult to tackle. And the national competition authorities and the academic discussion seem to go farther in the sustainability debate that the Commission finally does. But for now, and for us, the Commission provided at least a uniform interpretation after many calls for clarity, and serving judges and national competition authorities as a guide for interpretation and enforcement of Article 101. And thank you for your attention.
Okay, thank you, Maria, for this insightful presentation. I think these issues will continue to be topical matters for many years, since they go to the heart of competition law. As it has already happened several times, we are forced to some extent to reconsider our ideas and conceptions of antitrust law. This demonstrates that this subject is constantly evolving, being an inexhaustible source of new inputs and trends. It is now time to thank you all for your attention. I think that we exhausted the arguments, but I hope not the participants. Nevertheless, I think we deserve a little pause, which is why, before moving to the following section of the conference, I assume we can start our coffee break. Thank you very much.
Well done, well done. That was very fascinating.
Thank you, Master
Adam Scott.
Adriano Raffaelli. Nice to meet
The you raised the subject funding. We now have 200 billion of collective actions in front of us.
Yeah.
And also, the funding agreements are probably unenforceable, but they decided for against one.
Yeah, I understand. This is a problem. I was a close friend of Peter Roth.
Oh, yes. But you know, Peter has stayed on because he's retirement age.
Yeah.
So Peter was going to retire last December when he was 70, and I'm 75. So Peter is still my colleague.
Very well.
I should explain that. I am 76, but they have
Actually, me, I am 74.
Yeah. So
Say hello to him because I met him 1 year ago. The competition of French Tribunal, and I know that he now retired. But once again on the court.
oh yes, yes, yes. No, because
remained.
they changed the turning age, he was able to stay. It's very difficult for me because I have my immediate past president, Peter, and my new president. They both have ideas, and they both come to me and say, "Adam, will you do this?"
Okay.
And this is very difficult. Having an idea.
That's
I,
the name.
I can't believe it.
Marcus Smith is the new one,
Marcus.
and Marcus
Yes, I
is very different because he's full of ideas.
Ah,
But you mentioned this business of relationship with the authority.
yeah.
And next week, the authority is intervening in a standalone act.
Yeah. Oh,
Because as you probably realize, if we have a standalone act and we inform the authority, and the authority may choose to intervene, choose to investigate, and then we would have to stay the proceedings. It's quite.
cioè,
Questo da te.
sì, volevo.
However, thanks.
E lo posso tirare via?
Scusami.
Sì.
Questo ce l'ha.
Sì, sì, lascia lei. No. Ma adesso
Sempre Tavassi.
So they would be extinction. There is no requirement. So how can you have an effect on trade if there is no practical funding?
I didn't know all this was going on.
Allora, non so se mi hai risposto. Le slide. Sì. Molto importanti. Possono essere veramente
Yes. Ah, pero per conectarsi al internet.
Dobbiamo andare o
Che l'ho messa qua. Il mondo videone.
C'è ancora la mia presentazione condivisa. Ci metterò anche condivisione.
I
this session. Because on the timetable it says 12:45, which means we're all going to have to speak very, very quickly. The second thing to say is enormous apologies. I spent over 7 hours sitting at the airport yesterday trying to come, and there was so much fascinating going on yesterday that I would have liked to hear. Now, Rihanna's just asked me about binding effect, and I'm conscious that that's going to your Court of Cassation. In the preparation for the Damages Directive, we had much discussion about this because there was a spectrum. In Germany, they regard the decision of any competition authority as binding. In Denmark, they couldn't see that any decision, even if their own national competition authority, could be binding because an administrative body cannot bind the judicial body in their view. So there has been a fundamental problem about this. In the United Kingdom, we now distinguish between settlement decisions and ordinary decisions. For various highly technical reasons after Brexit, a Commission decision relating to infringement before Brexit is binding. After that, if it was a settlement decision, we regard it as wrong for a defendant to be able to plead that there was no infringement. And we regard that as an abuse of judicial process. And it'd be interesting to know, think about this in your own jurisdiction. Is it an abuse of process for a defendant to claim that a decision by another competition authority, which they settled, whether the Commission or another national competition authority, can then be challenged before a court? So that's an interesting thing. We also had the question about the annulment of judges with expertise. That's been a problem for us on the tribunal, and we're now seeking legislation to deal with that. We've upped the retiring age to 75, so Peter Roth is still with us. And we're hoping that our digital legislation will address that. Mention's been made of collective actions. Collective actions before the tribunal now amount to over 200 billion, so even more in euro. The funding issue is now fundamentally up in the air because our Supreme Court decided 4 men against Vivian Rose that most of the funding agreements were probably unenforceable. So we are addressing that as a problem. The question came up, Marina, of the role of the authority. The Damages Directive has the authority helping the court in 2 ways, one in relation to disclosure and the other in relation to the quantification of damages. With us, if it's a standalone action, you inform the authority, which can then decide whether to intervene or to investigate. And if the authority wishes to investigate, we should stay the proceeding. Now, next week on Friday, we have a case, Le Paterel, in which the authority has asked to intervene. We have given them permission to intervene, and we have protected them from any costs order. So there's a lot going on. Applicable law has come up, and deciding applicable law and the whole issue of the application of the various rules that you heard talked about can be such a complicated issue that we had the carbon brushes case, a claim for 900 million euro plus interest plus costs, and we spent 7 years working out who could sue whom for what, where, when there was parallel proceedings in the United States. And after 7 years of that, the parties settled. So that aspect of these private damages claims can be an enormous part and will go on being an enormous part. Who can sue whom for what and where? So there are a lot of challenges for judges, and these are going to be complicated by the horizontal guidelines. We've just had a meeting of the judges with DG Comp, which focused on 4 of the chapters, including sustainability. And I foresee some real difficulties of judges trying to get that balance between what the Commission is trying to do with a lot of different priorities and doing law. So it's a great joy to have younger academics, because you are able to say things that judges can't say. May not be aware of that, but that's true. So I think without further ado, I should turn over. And we're going to look at the role of commitments. Now, for national judges, commitments are becoming very important because a commitment does not foreclose the possibility of a standalone action. And commitments, the great advantage of people giving commitments for a claimant is that you only have to prove breach of commitment. You don't then have to prove infringement. Over to you.
Okay, thank you very much for the introduction. I have like plenty of slides, but mainly because they will be updated in the website of our project. So I will try to go very fast because the number is too much to be dealt in the time we decided to keep our speeches. Very few words in order to introduce the notion of commitment decision, with which I assume we are all very familiar. Commitment decision were introduced based on similar instruments already in place in the US or already used informally by the Commission in Regulation 1 from 2003. They changed the way antitrust works. They changed the way the Commission, deal with anti-competitive practice, because in many instances it's very convenient for the Commission to try to seek a commitment, to negotiate a commitment with the undertakings involved in a proceeding rather than the Commission and national competition authorities. I will talk about the Commission, but the situation is very similar with national competition authorities, which have been granted and obliged to have this, to be able to, member states were obliged to confer the power to national competition authorities to execute commitment decision by Directive 1 of 2019. So the situation is similar. They changed the way antitrust works essentially because from the exercise of authoritative powers by a public authority, it becomes largely, let's say, a matter of negotiation between the competition authorities and the undertakings. Indeed, formally speaking, the undertakings shall propose the commitment, but as we all know, as a matter of fact, even before the undertakings formally propose the commitment, there are negotiations and discussions between the enforcer and the undertaking in order to see if it is possible to follow this path rather than going through the full adversarial procedure. This also shows that one of the limits which are set by both Regulation 1 of 2003 and the directive, meaning that commitment shall be used only when the Commission believes it is not necessary to issue an infringement procedure where the infringement is not serious enough to deserve, for example, a fine, are not very, let's say, binding for the Commission, which usually select the cases based on other elements, and the practice shows that commitments have been used indeed also in the most serious cases, in cases related to the most important infringement of competition law, even cartels. In a few cases, there were hub and spoke cartels, say, in the context of which a commitment decision was adopted. There are strong incentives for both the Commission and the undertakings to follow this path. From the viewpoint of the Commission, well, let's begin with the undertakings. The most easy to understand is that there is no fine. And in addition, there is, as we will see, and as I will discuss in more detail later on, there is also a strong possibility to avoid following civil litigation. The commitment decision, of course, does not entail any acknowledgement of the infringement. There is no finding of the infringement by the public authority. This somehow, and we will see how, impact on the private enforcement. it is a way to contain cost. I mean, if you look at the matter from expected cost and expected benefit of an infringement of competition law, commitment decision, just as settlement decision, may reduce the expected cost by the undertakings with some effect on the deterrent effect of EU competition law. From the viewpoint of the Commission, the incentives are mainly related to procedural efficiencies. There is no statement of objection. There is no need to prove all, let's say, the most relevant matter that shall usually be built by the Commission before closing a procedure. There is no need to, let's say, to build a decision which is bulletproof because it won't be appealed before the General Court, to keep it very short. The relevant market may be discussed in a few lines rather than in 20 or hundreds of pages, and the same apply for the dominant, for establishing a dominant position, for example, and so on. It is very easy for the Commission to close a case with a commitment decision, which also entails that, in theory, the Commission may use its limited resources to pursue other cases. So it could be, let's say, efficient to have this, and it is efficient to have this instrument in place. Commitment decisions also allow the Commission and the national authorities to pursue goals which are not strictly related to competition law, which are regulatory, which have a regulatory nature. Since there is no longer a strict connection between the conduct of the undertakings and the content of the decision, the practice shows how the Commission has essentially used in plenty of cases this instrument in order to support let's say, the reform of given markets. Just think about the energy sector. The Commission included in commitment decision, adopted and, let's say, negotiated with the national incumbent and, in any case, the most important players in many member states, some obligation which the Commission did not succeed in convincing the Council and the European Parliament to be included in all the energy market packages, let's say, especially if we look at the matter from the perspective, from looking at the time when this wave of commitment decision related to the energy market were adopted by the Commission. Then progress has been made in the new energy packages, I mean. This also, the fact that the commitment decision allowed the Commission to push these regulatory functions to look at the future, how the market shall, let's say, function in the future, rather than focusing on what has been done in the past on the antitrust infringement. Also because there is the principle of proportionality is very, let's say, the application of the principle of proportionality is very limited when it comes to the commitment decision. So this gives much leeway to the antitrust enforcers to draft the commitments as they wish. I mean, as long as the undertakings will agree, anything can be put in a commitment decision. So also from the perspective of the undertaking, it is a matter of whether the content of the commitment will, let's say, affect the core business of the company. If not, the undertakings may be willing to accept everything, even unrelated to the alleged conduct, the allegedly anti-competitive conduct, in order to avoid to go through the ordinary procedure. This also may explain why the commitment decisions were included also in the digital market. Within the context of the digital market, the European Commission can carry out market investigation in order to check inter alia whether let's say there have been systematical infringement of the DNA itself by the gatekeepers. If it finds out that there have been systematical infringements, which essentially means a certain number of infringements in a given period of time, the Commission may decide to either issue a decision addressed to the gatekeeper imposing the behavioral or a structural remedy in order to address this systematical violation, or to adopt a commitment decision. Here, I mean, essentially what I will discuss later on, I think it applies to both the categories of the commitment decision, both under competition law and under the Digital Market Act. However, I don't really understand why the commitment decisions have been included in the Digital Market Act. My doubt is essentially the following one. I mean, commitment decisions make sense in the context of antitrust because they allow the Commission to avoid to establish which is the relevant market, which is the conduct, and all the constitutive elements of the alleged antitrust offense. When it comes to the Digital Market Act, this is the very purpose of the Digital Market Act. I mean, we have already the obligation established in Article 5, 6, and 7. We already know who are the gatekeepers. I don't see the procedural savings that can be achieved by the Commission through a commitment decision in this case rather than adopting an ordinary decision. The only element that comes to my mind is that the commitment and taking this argument from the general practice under Article 9 of Regulation 1/2003 is that probably within the context of the commitment decision, the proportionality limitation will not apply or will apply in a different way. So the Commission may wish to, even if the DMA is already, let's say, a quasi-contractual litigation from the viewpoint of the parties, and commitment decision are even in the antitrust perspective, a quasi-litigation perspective, the Commission may have included the commitment in the Digital Market Act, probably to try to reduce the scope of application of the proportionality principle, but I'm not sure about that. But let's move to the, I mean, after this, I hope it was a brief introduction. I hope to still have time to discuss the main. Let's move to the interplay between commitment decision and private enforcement of competition law. Essentially, there are, in my view, three scenarios to have a look at, and I hope I will be able to cover all of them. The main one, the most common one, is of course the one where, let's say, there is a commitment decision, and then someone try to enforce that decision before a national court in order to, for example, get damages. In the ordinary scenario, therefore, is the one where the same conduct which is covered by a commitment decision is also the subject matter of a civil case. However, there are, from the temporary viewpoint, there are other two options to be taken into consideration, in my view. Let's say that the second one is what happened with the conducts which occur after the issuance of a commitment decision, whether, for example, the undertaking, what happens if the undertaking does not comply with the commitment, or also can, let's say, does compliance with a commitment decision shield the company from potential private litigation? Is complying with the Commission, with the commitment decision enough to be sure that there won't be any cases, any other, let's say, cases brought for a violation of competition law? And also, but this is less, let's say, straightforward, one can wonder whether there is a difference also when it comes to what happened before the commitment decision. But I will, if I will have time, I will discuss it later on. Of course, I mean, I went through all the different approaches that ever since the entrance into force of Regulation 1/2003 were put forward. So we can see from, let's say, one idea, which was essentially that the commitment decision should have granted to the undertakings a sort of immunity for civil action, because this was necessary in order to ensure, to protect, to safeguard the effectiveness of the instrument. I mean, when a company decides to negotiate commitments, this was the idea beyond this approach, was they should know that there won't be any private litigation after the decision to commit and to accept some obligations. On the other end, at the other end of the spectrum, we have the position according to which a commitment decision is the same as an infringement decision, and because let's say that the acceptance of the commitments could be considered as a sort of confession of the antitrust offense. Both are, let's say, wrong. They are not what the practice in the end has proved to be the correct reading, but we will go through everything in between these two approaches to the matter. Well, the first one, of course, I mean, it was wrong. Even it was possible to conclude that saying that commitment decision could grant an immunity to the committing undertakings was not a correct solution simply by reading the text of Regulation 1/2003. It is written very clearly that commitment decisions do not affect the power of national courts. We will see, however, how the case law of the Court of Justice has somehow reduced the scope of application of recital 13 and 22 of Regulation 1/2003. However, already, I mean, in the aftermath of the entrance into force of commitment decision, already many national courts recognized that there could have been no immunity from civil liability. And I guess plenty of these judgments were rendered by someone who is in this room, actually. One can also try to, let's say, see if commitment decision could somehow even foster private enforcement. This is related to something that I said earlier. If we think of the commitment decision as a way to, let's say, free the resources for the Commission, we could argue that the Commission will decide more cases, that there will be more decisions of the Commission, both commitment ones, but maybe also ordinary one, infringements, the one finding an infringements, and therefore that from a general viewpoint, there will be, let's say, a net positive effect for private enforcement because claimants in general, prospective claimants, will have more decision to enforce before national courts, and we all know that, let's say, follow-on actions are more likely to be brought and more likely to succeed than standalone ones. However, if we switch from the general perspective, it could be true that the Commission can decide more cases if handling a case is easier, I mean, under the commitment route rather than under the ordinary one. But if we look at the position of, let's say, not the general perspective, but the position of those who suffer harm from a given conduct, the conduct which is the subject of a commitment decision, the situation is probably different. Of course, the basic idea is that, as we discussed earlier, the commitment do not include any acknowledgement of the infringement. There is a prohibition for the Commission and the national authorities to discuss the existence of the infringement. It means that by this very this very characteristic of the commitment decision, let's say, we immediately understand that when it comes to the enforcement of a commitment decision before a national courts, we are somewhere in between a full standalone case and a follow-on action. The matter is deciding where we decide to stand between these two different scenarios. Of course, one thing is to say that commitment decision shall grant an immunity, and we have seen this is not the case. Another thing is to discuss the evidential effect of the commitment decision. Here again, we have plenty of different approaches. One can argue that the commitment decision does not prevent the possibility to bring a civil action. There is no immunity, but nevertheless, it is of no use at all for the prospective claimants. The prospective claimants can, let's say, submit the commitment decision before a court, but the court shall essentially ignore it, as it does not contain any reference to the infringement. This was put forward actually by many scholars, and there are also a few cases in which this reading of the matter, which is essentially the same as saying this is a full standalone cases, but the practice has, let's say, developed in a different way. Why? Well, essentially because the commitment decision, yes, it is not an infringement decision, but it is not even a decision where the Commission, let's say, closed the case without issuing any decision at all. It is not a clearance decision. it is something in between. Also, because it is true that there are procedural savings, generally speaking, there are no statements of objection, but nevertheless, the issuance of a commitment decision should be based on a competitive concern raised by the Commission or a national authority. Otherwise, the system does not work. I mean, okay, the Commission used the instrument to pursue regulatory goals, but in theory, there should be some link to an anti-competitive practice. Otherwise, the principle of proportionality and more generally, the principle, the conferral of power to the Commission should say that the Commission should not act if there was no competitive concern at all. So this competitive concern shall have some role when it comes to the following assessment by national courts of the content of a commitment decision. We know that as a matter of principle, the matter was decided or was the subject of an important judgment by the Court of Justice in 2017, which was the Gasorba case, where the Court of Justice essentially recognized that commitment decision shall be taken into account by national courts as an indication or even as a prima facie evidence of the anti-competitive nature of the conduct at stake. So the Court of Justice provided quite a significant support when it, with regard to the possibility to, let's say, make the private enforcement of commitment decisions more likely to happen, because they shall be taken into account, the competitive concern shall be taken into account, and it can even be a prima facie evidence of the infringement, even if the decision does not include any acknowledgement of that. The same, I mean, the matter was again decided more, discussed more recently in the Paramount Canal Plus case. The decision of the court, I put it in the slide for a different matter, we will see it later on, but especially the Advocate General Pitruzzella again discussed the evidential value of the commitment decision, stressing out that the commitment decision, I mean, that is based on a potential infringement of competition law, that the Commission is not allowed to issue commitment decision if it does not have, let's say, not a full theory of harm, but nevertheless, a theory related to a potential violation of EU competition law. If we have, I mean, so we have a basic framework set by the European Court of Justice. It shall be taken into account. It may be an evidence of the infringement. However, how these, let's say, instructions given by the Court of Justice are used by national courts is still a matter. I mean, the practice is still very different. There are cases using this principle in very different ways. Following the judgment in Gasorba, once again, it is not a matter of, well, yes or no, can we have private enforcement of commitment decision, or we can't. It is sure we can. The matter is only to understand which is the useful effect of the commitment decision, what utility the claimants can gain from the content of the decision. This is related to the very nature of the instrument. If the decision is very short, generally speaking, 20 pages, 15 pages compared to 200 or more pages of the decision, of the ordinary decisions, it is clear that regardless of the acknowledgement of the infringement, even the text of the decision will provide very limited, let's say, elements to be in order to convince the national courts that an infringement occurred. Here, well, we are, let's say, moving from all the different views that I mentioned earlier. These were essentially, even though we can still find this reference in more recent case law, these were mainly principles established in the very first occasions in which the matter was dealt with. There are, I selected a few cases from Italian courts, a few from the Court of Milan and a few from the Corte di Cassazione. Quite recent one which approached this matter in a quite different way. Here, in a fairly recent decision of this court, of the Court of Milan, you see, let's say, a restrictive approach to the value of a commitment decision. Essentially, the Court of Milan said, well, yes, we cannot ignore it. It is a document. It is a document which has been submitted by a party. It shall have at least the same value as all the other documents submitted by the parties, which is a very narrow reading, let's say, of the value, of the evidential value of a commitment decision. In this case, the Court of Milan essentially decided that follow-on action based on a commitment decision are actually full standalone cases. If we move to the case law of the Corte di Cassazione, we see different approach to the matter. In one fairly recent case, 2021, the Corte di Cassazione said it is the principle of proof of the infringement, as if the basic reasoning is if the undertaking decide to accept commitment or to propose commitment, actually it means that it has done something. So yes, it is not a full confession, but nevertheless it can be a principle of proof that something were, let's say, not fully lawful. In a more recent case, 2020, the Corte di Cassazione went even a little bit further and said that commitment decision may create a rebuttable presumption of the unlawfulness of the conduct. This was, let's say, a case, if I remember correctly, in which the factual circumstances were quite peculiar, because it was the last one of the last instance judgments given on the case law, which was originate in the Tribunal of Milan, related to a case where only one of the undertaking involved in a public procedure brought by the Italian National Competition Authority decided to propose commitment and have the commitment made binding by the Italian competition authorities. There were ordinary infringement procedures rendered against the other companies, which were, let's say, all the addressees of the statement of objection, and the Court of Milan, the Court of Appeal, and then also the Corte di Cassazione decided that in this sort of hybrid situation, let's say, on the one hand, it is possible to make a cross-fertilization between the different decisions of the authorities. So it is possible to use the infringement decision addressed to a given undertaking to, let's say, take element from that decision, which is more detailed, which is longer, and so on. Also, if you bring a civil case before the only undertaking who proposed commitment. So the Court of Cassazione said it can create a rebuttable presumption, but the facts of the case were rather peculiar. Why we still have all these difference and different approaches by the national courts, and I focus only on the Italian one, so I assume, I read something also with regard to other member states, and I see that essentially in many instances the situation is not much different. Essentially, because it is a matter also, we should also have a look at the specific decision issued by competition authorities. For example, I put it in the slide one, in which the Commission will very clearly, let's say, try to protect the position of the undertaking from potential following litigation. You see how the Commission was careful in avoiding any elements that could somehow be used in a following litigation case before a national court. It is also, because the point is that, of course, the potential indemnity for following litigation gives the Commission some leverage in the context of the negotiation. So it will depend by the single case. There will be cases in which the decision, if in order to achieve a particular commitment by the undertaking, the Commission is willing to, let's say, draft a less detailed decision to avoid all the references that may be useful for following litigation, the Commission will do so, and the decision will be much less useful in following litigation. In other cases, the decision, even the decision under Article 9 of Regulation 1 from 2003, may contain some details that may be useful in following litigation. We already discussed the hybrid procedures. What commitment decision may help? There is a situation in which commitment decision may for sure be helpful for claimants that may be, on the one hand, to obtain interim measures by national courts. I mean, here, let's say, even that essentially what my point is that there is no difference when an antitrust authorities begin a procedure. Of course, not the reference is not to the final decision yet, especially because we are talking about interim measures. There is not much difference if an antitrust authorities begin a proceeding with a statement of objection. So with the idea, let's say, so that can be changed, but with the idea to go the ordinary route, or by sending the different, let's say, first document that shall be addressed to the undertakings, only showing some competitive concern. This competitive concern is probably enough for a national court to believe that at least the fumus boni iuris is met. Also, probably the decision, the adoption of a commitment decision could be used by prospective claimants in order, for example, to meet the threshold that are set by Directive 104 of 2014 in order to have a national courts ordering disclosure or ordering or to get access to the file of a competition authorities. There is no infringement, okay, but there was a competitive concern. So this competitive concern, in my view, should be enough to meet those thresholds. How much time? I lost track of time, so I may be, it's over.
You draw things to a conclusion, and then I will talk to people about time.
Okay, well, so I don't really know to conclude because I still have the two other scenarios to be dealt with, but so I will go very quickly through the other scenarios. And essentially, there is a remedy set by the regulation. What happens if an undertaking does not comply with commitments? There is a public remedy provided by the regulation. The Commission may reopen the case. What is the role of national courts, however? Does this remedy prevent national courts to take any measure if a private party bring a claim claiming that there has been a breach of the commitments agreed by another undertaking and the Commission? Here, I found a recent case by the Court of Roma, which seems to say that this is that taking care of what happened in case of an infringement of a commitment is an exclusive competence, in this case of the Italian National Competition Authority. I tend to fully disagree with this decision, essentially because commitment decisions are a source of EU law. Commitment decision as a source of EU law, if they are clear, precise, and unconditional, if the obligation, and this is usually the case, as the commitment undertaking shall comply with the obligations. If the obligations are clear, precise, and unconditional, they have direct effect, and as a consequence, it should be possible for everyone to rely on them in order to go before a national court and have the right, which is the other side of the obligation of the commitment undertaking, enforced by a national court. This is essentially a contractual litigation. You, as a private undertaking, let's say as a private claimant, you do not need to engage in the complex antitrust litigation. It is more similar to the prospective kind of litigation that will arise around and following under the Digital Market Act. You have clear obligation. It is whether the committing undertaking has or has not complied with its obligation under the commitment decision. You can try, depending on the case, you can try to have to bring a claim to have the court ordering the committing undertaking to comply with its obligation under the commitment decision, or to claim damages if you suffer damage from the violation of the commitment decision. Is it possible to envisage action also in the case where the undertakings has complied with the commitment? Well, here it is less straightforward. I mean, one would probably tend to say, no, the undertaking who complies with its obligation under the commitment decision has done its job. However, if you look at the matter from the, let's say, the perspective of how the commitment decision is drafted, if the commitment decision could provide a sort of immunity also from any future conducts, it would mean that when the decision is drafted, the Commission shall assess whether compliance with the commitment is enough to be sure that no more antitrust offenses can occur in the future, which is something impossible to prove, and the Commission does not do that when it issues a commitment decision. So the point is that even complying with a commitment decision should not be considered as something preventing the possibility of new antitrust offenses occurring, and therefore preventing the rights of individuals to claim damages. Of course, it will be more than a standalone case, because you will have to win the presumption stemming from the commitment decision that the conduct of the undertaking is lawful. So it is a theoretical, let's say, scenario more than a practical one. What instead was the subject of the Paramount Channel Plus decision of the Court of Justice was a slightly different position. As commitments do impact and affect the position of third parties, because while imposing obligations on the committing undertaking, it is likely that this commitment may affect the position of other parties which have in place contractual relation with the committing undertakings. The question decided in this case is essentially what are the remedies at the disposal of these third parties. The Court of Justice decided that a third party cannot ask a national court to oblige the committing undertaking to breach the commitment. It is in other words, it is not possible. Here it was what I mentioned at the beginning. The scope of the recital 13 and 22 of Regulation 1 from 2003 has been somehow reduced by this judgment rendered by the Court of Justice, because national courts can no longer adopt a decision with which they allow, let's say, a company to breach the commitment that has decided to be bound with, even on the application of a third parties who, let's say, had a contract with the committing undertaking, and following the decision of the committing undertaking to accept commitment in the context of an antitrust procedure, can no longer rely on the content of the contract, because some of the provisions of that contract was set aside by the commitment decision. Now, I think I will simply not discuss the last topic and leave the floor to all the other speakers. Thank you.
Let me just talk for a moment about what you've said. We have here lawyers who act for defendants or prospective defendants. And part of the task, it seems to me, when negotiating with an authority, and the authority is in a very strange position, because on the one hand, they want the matter off their desk, and on the other hand, they are conducting a quasi-judicial investigation, and there's a real conflict going on there. From the point of view of the courts, you want a decision that is clear and understandable. Most decisions which flow from commitments or settlements have very little content when it comes to looking at infringement detail effect detail, causation detail, let alone quantification detail. Very few judges find help from decisions, unfortunately. And that's understandable. And if it's a settlement or a commitment one, it's part of the job of the lawyers representing the parties to ensure that the decision contains as little detail as possible. Now, you've heard about disclosure, and that's can be very important here. But so you've got a real problem going on there as to what happens here in practical terms for judges. You've talked about breach of condition. As I said earlier on, the advantage of a breach of condition is you don't have to prove infringement, you only have to prove breach of condition. And maybe you should send a textbook on tort and delict to the people in Rome so that they understand the rights of parties under European law. The other thing, and this is where we get into the DMA, is the discussion that's been going on about how far authorities, including the Commission, should be able to look at a market and to consider what is going wrong. Now, the big threat that exists is for the authority or the Commission to go to a party or parties and say, if you do not give commitments, then we shall launch a full-scale investigation, and that is going to take a lot of your time and money and attention. So thank you very much for that. Now, how long do you need for lunch? In the original program, you had 105 minutes. If our two next speakers take 20 minutes each, that comes down to 65 minutes for those who are not going on the tour, or 35 minutes for those who are going on the tour. So I need a quick jury decision. You can smile or frown at me as to whether you are prepared to shorten your lunch, because otherwise you can go and take your lunch and the rest of us will go on listening to our speakers.
We can also shorten our speeches.
Right. Okay. Okay. Well, I'm enormously grateful to Filippo for that suggestion. So over, you choose what.
No, I can stay here.
You can stay there. You don't have slides. Excellent.
Yes, but you can speak.
So this is good for your figures.
So thank you, Mr. President. I will start taking the time of my speech, so I will be as precise as I can. Thank you very much. Which is the role of national judges in the application of the Digital Markets Act? In other words, can we identify some room for private enforcement of the DMA? These are the questions that I will try, the complex questions that I will try to answer very rapidly today. The first point that I want to make is that in the DMA proposal, when the Commission put forward the proposal, many people noticed that there was not any word about national courts. So there was a complete silence on the role, on the prerogatives, on the powers of national courts in applying the DMA. And of course, a lot of criticism was raised in this respect because we know that national courts in the EU legal system, whatever the subject or the area of law, are extremely important for the enforcement and application of EU law. So during the legislative process, there were some proposals for amending the original proposal DMA of the Commission in order to include some provisions on the role of the courts. And in particular, it was raised the need to clarify two main aspects. First one is the mechanisms for cooperation between national courts and the Commission. and this point has already been mentioned this morning by Tavassi. We have the provisions laid down in Article 1 to 2003, which are quite clear on the possibility for the judges to request information, opinions to the European Commission, and the possibility for the Commission to take a role in national proceedings. The second aspect that was considered as necessary in terms of clarification and new provisions in the final version of the DMA was more generally the private enforcement of the DMA, which I was mentioning before. So the need to clarify the scope of application of private enforcement and or to lay down some specific procedural rules, potentially, but I will go back to this point very soon, similar to the ones laid down by Directive 2014/104, the so-called damages directive, as far as the private enforcement of competition law is concerned. And in the latter regard, so with regard to this second aspect, the clarification of the scope of private enforcement of the DMA, there were also official and institutional positions that were taken. One of them was the one of the so-called Friends of an Effective Digital Markets Act, a sort of group including the ministries for economic affairs of France, Germany, and the Netherlands, who issued a non-paper in 2021 entitled Strengthening the Digital Markets Act and its Enforcement. And in this paper, they were also mentioning the issue of private enforcement, saying that private enforcement would further increase the effectiveness of the DMA. Therefore, it must be clarified that private enforcement of the gatekeeper obligations is legally possible. If we look at the final version of the DMA, we can see that the first point that was made was considered. So we now have a provision, Article 39, on cooperation between national courts and the Commission. While the second suggestion, the second point, clarifying the scope of the private enforcement of the DMA, was not really considered by the European legislator, because we basically don't have any specific provision in the DMA in this respect. On the first point, we can mention Article 39, which is composed of 5 paragraphs. And basically, as it was also mentioned before, the first 4 paragraphs reproduce Article 15 of Regulation 1/2003. The 5th paragraph basically reproduces Article 16 of Regulation 1/2003. So in the first 4 paragraphs, we have the possibility, as I was mentioning before, for national courts to request information and opinions to the European Commission. The Commission may submit written observations to national courts in the framework of national proceedings, and also make oral observations. And for the purpose of the preparation of such observation, the Commission may also ask national courts the transmission to the Commission of any documents necessary for the assessment of the case. And I also want to mention the issue of the transmission of the duty imposed on member states to transmit a copy of all the written judgments that are adopted in the respective legal orders to the Commission. This provision is reproduced in identical terms as it was drafted in the regulation, and this is the reaction. Thank you. I think our chairman gives us the perfect idea of what one thinks when reading that provision.
Let me interrupt. The problem about Regulation 1 of 2003 is it's not a directive. The problem about the Digital Market Act is not a directive. If it's not transposed into national, judges do not see any duty on them to transmit the judgments. The duty lies in an amorphous state. It can only be enforced by infringement proceedings before the Court of Justice, and none have been brought. So this is, let me stop interrupting, but we are working on this.
Thank you. Sorry.
If I may add, actually, as a former president of my court, our current president of the Republic told me when I reminded her that we have this obligation. Well, the Commission must communicate a procedure for sending the judgments first. Then we will comply.
Yeah, just so you are aware, the Association of European Competition Law Judges has a project on this called UK-JUD, and we need some funding for it, but that's another story. You know, this is a serious issue that we have at the moment, that it's not easy for national judges to find what decisions are being made by national judges. It's not easy for the Commission to know what's going on. And so this whole business of the Commission being able to intervene, to make amicus curiae observations, and to understand what's going on is a real challenge, and the DMA is simply going to exacerbate that challenge. Sorry to interrupt, but this is, you've probably realized, a little bit of a passion. The other problem we have for the Association of European Competition Law Judges is, does the DMA take us outside the area for which we have been responsible? And the Commission are wondering, should we be recognized in EU law by being incorporated in the revision of Regulation 1 of 2003. So there's a whole lot of issues going on about how the judges fit into a lot of this. You have the ECN, but you don't have us recognized as judges as a group yet.
Thank you very much. If I may add two very quick points on this, I don't want to blame judges because the obligation is expressly put on member states.
Oh, absolutely.
So also the member states, governments or legislators could have introduced a procedure to enable. But in any event, it is a fact. If we go on the website of the Commission and look at some old section in which these judgments should be published, we can really see a few judgments. For Italy, I think there are 5 or 6, which tells us that, of course, it is a completely unimplemented provision, and it's quite surprising to see it 20 years after Regulation 1 2003, identical, without any kind of sanction or more specific indication. But okay, I can also add, but very rapidly, that we have in Italy a website on which we try to collect all the judgments of national courts, which was set up also thanks to Marina Tavassi and her help as member of the Court of Appeal of Milan. But yes, in other member states, we don't have such kind of tools, and therefore I think the Commission should try to do something in order to improve this point. But going back to Article 39 DMA, we also have a 5th paragraph, which I was mentioning before, which reproduces Article 16 of Regulation 1 2003. So basically, this provision tells us that national courts shall not give a decision which runs counter to a decision adopted by the Commission under this regulation, and also a decision contemplated by the Commission. This point was also mentioned yesterday, so I can be quick. But let me say that this is a provision that has raised some concern, and as it was mentioned before by Mr. Raffaelli, it's going to be discussed before the Supreme Court of Cassation in Italy. The DMA reproduces this provision as it was in Regulation 1 2003. So the first point of criticism, cooperation between national courts and the Commission, was clarified. The scope of private enforcement was not really clarified by the final version of the DMA. We have just one recital number 42 of the DMA regulation, which says that to safeguard a fair commercial environment and protect the contestability of the digital sector, it is important to safeguard the right of business users and end users to raise concerns about unfair practices by gatekeepers, raising any issue of non-compliance with the relevant union or national law, including with any relevant administrative or other public authorities, including national courts. So the small reference is the only point in which we have a clear idea of the fact that business users and end user can bring cases before national court. For the rest, we have a sort of silence of the regulation. Of course, the provisions I mentioned before assume that the private enforcement exists, because, of course, in order to realize a form of cooperation between national courts and the Commission, you need some cases to be brought before national courts. But what is quite striking is that we don't have any idea by reading the regulation about the possibility or not to apply, at least in part, the rules that were introduced by the Damages Directive in the field of the application of the DMA. This is quite strange because the role of national court in ensuring a rapid and effective application of the rules of the DMA is widely acknowledged. The Commission will not be able, most probably, to manage all the workload and all the complaints that will come from consumers, business users, competitors, and so on. And therefore, the action of national courts will really be essential. One may wonder why not extending the applicability of the Damages Directive. It's not an easy point. I don't want to be too quick on this, because of course, one may say, we have to be careful. The DMA is different from competition law. We know it has an ex-ante approach. It is a regulation tool. And yesterday we heard especially Ginevra Bruzzone discussing this point. And so it may not be straightforward to apply the rules of the Damages Directive to private actions based on the DMA. This is a position that can be, of course, supported or put forward. In my opinion, for the purposes of private enforcement, they are not so different to justify a complete lack of application of the rules introduced following the path that we know in the field of competition law, but still one may say we don't want to apply those rules. But the problem is that in this case, the Commission and the legislature did not say anything, so we don't know precisely what to do in this respect. What was done, to be honest, to be complete, on the website of the European Commission is publishing some Q&As. We have question and answers of the European Commission about the DMA. And among these Q&As, we have one question saying, will private damages be available to those harmed by gatekeeper conduct? So in this case, the point is tackled. And the answer of the Commission is that the DMA is a regulation containing precise obligations and prohibitions for the gatekeepers in scope, which can be enforced directly in national court. This will facilitate direct actions for damages by those harmed by the conduct of non-compliant gatekeepers. So we have an answer of the Commission in an informal document, in not even a soft law provision, because it's just an explanatory web page, but we know that damages actions are, of course, possible, that they should be facilitated by the fact that the DMA is regulation, and we know that all the foundation of private enforcement in the EU system is direct effect of the provisions.
I intervene because it's important to do two things. First, to look at the Damages Directive and to ask yourself, what here is codifying existing EU law? The Commission have recently asked me to write on this in relation to state aid because of the failure of private enforcement in state aid. The second thing is to consider in the procedural terms of national law, what steps should be taken in national law better to improve the effectiveness of the application of private enforcement, not just in damages for enforcement of 101 and 102 and national equivalents, but also 107 and 108, and now of the DMA. And there is lots that can be done procedurally at national level to make private enforcement effective and also, therefore, equivalent, because you've got it in your procedural law at national level.
So yeah, the foundation is direct effect, and therefore we would give a look to the main provisions of the DMA, laying down obligations and prohibitions, and in some cases rights, as it was mentioned yesterday, but mostly obligations and prohibitions, and wonder if these provisions have direct effect or not. As you know, we have, first of all, Article 5, so-called direct applicable obligations and prohibitions. And in this case, it is quite sure that this provision has direct effects. So for this category of obligations, in principle, anybody who wants to invoke these provisions before a national court will be enabled to do so. Then we have the provisions laid down in Articles 6 and 7, obligations subject to further specifications, which may raise questions on the fact of having direct effects or not. The main answer that I have found among the first commentators is that given that the specifications concern in reality not the content of the obligation, but the ways in which the gatekeepers will have to comply with such obligations, also these two provisions can be considered as having direct effect. So in principle, a very wide scope of private enforcement of the DMA. But the question remains as to under which procedural rules. In principle, in the lack of any express extension in express terms of the damages directive, national law applies. So the procedures will be governed by national procedural rules, just like it was before the damages directive in the EU competition law field. One may wonder why forgetting 20 years of evolution and a directive, but still it could be an option. What is the problem here? If we look at national law, what happens in the member states of the Union, we know that, for instance, Germany has been very active in the field of digital markets and digital platforms. On the 7th of November 2023, the German Competition Act was amended. There was the 11th amendment of the German Competition Act. And among the new provisions, we have two new provisions which lay down expressly the fact that the disclosure rules and the limitation periods rules introduced by the damages directive will also apply to the private enforcement of the DMA. So in Germany now we have a partial extension of the procedural rules, also the substantial rule if you take limitation periods of the damages directive to the DMA. But this would not apply in principle in other member states of the EU. So the objective of avoiding fragmentation between member states, that was one of the main objectives of the DMA, becomes to some extent problematic when we look at the private enforcement of the DMA, because a clear position would have been much more advisable even to avoid this kind of differences between the member states. So I hope that, and I move towards the conclusion because I don't have much time left. Luckily, we have the preliminary ruling procedure also recalled in Article 39 DMA. So I think that national courts will be essential also in this respect, that some questions will be raised before the Court of Justice, which will have the possibility to clarify some of these aspects, but I think that in legislative terms, it is quite a problem, the fact of not having regulated this aspect in detail. A few words on to conclude on the main issues that we can consider for private antitrust actions, for private enforcement actions based on the DMA. First of all, in principle, both follow-on actions and standalone actions seem envisageable. So it will be possible. Some had proposed, some authors had proposed to limit the application of the DMA to the one or the other category of actions, but this would have been reasonable, most probably. And in any event, this was not the choice of the legislator. Especially standalone action will be very useful because of the need for rapidity that is inherent to this area of law, as we know, into this kind of markets and this sector, as we know, especially the precautionary measures that will be taken, that can be taken by national courts, can be particularly useful for the reasons that I was mentioning before. Also, follow-on action are admitted, and we have that rule of reproducing Article 16 of Regulation 1/2003 that most probably will facilitate a lot follow-on actions based on decisions of the Commission, which find an infringement of the DMA. At the same time, the standalone action will be easier, most probably, for plaintiffs because you don't need, in the framework of the DMA, to demonstrate, as we know, the existence of a dominant position and the abuse of this dominant position. So the prohibitions of the DMA are much easier to be applied in principle before national courts, also for these reasons. But what happens if a plaintiff invokes at the same time the DMA and competition rules? This is a problematic point because also on the public enforcement side, we know that the relation between the two areas of law is not so clear. Most probably the same will apply to private enforcement. So this will be another point that will have to be clarified. Last point, but I will be extremely quick on this because I know that Mario Siragusa is saying maybe something in this afternoon. We have an issue of competence before national courts because it is not always clear if the rules on competence concerning the private enforcement of competition law apply also to the DMA. In principle, the answer is no. In Italy, for the moment, we have the rule that was mentioned before by Adriano Raffaelli, according to which three specialized courts are competent for this kind of actions. For the moment, the same rule is not applicable to the private enforcement of DMA. It is open to comments if it should be a good thing or not. In my opinion, yes, but one could say the consumer maybe needs a closer court, but I think the experience of specialized courts in Italy is very positive, and therefore it should be reproduced for the private enforcement of the. So to conclude, I would say that we are still. I am in the same position as someone who said before. I have many more questions than answers. It is not easy at this stage to make forecasts or to say what will happen with the private enforcement of the DMA, but I'm sure that it will be an important point to be seen. And I can say that, in my opinion, it is a bit of a missed opportunity, the fact of not having regulated it in a clearer way in the DMA regulation. Thank you very much for your.
Thank you very much. Believe me, you can put procedural steps in hand to focus the cases onto a suitably competent court. I can tell you more about how to do that if you want.
Mr. Chairman, can I say, as IGE, as the Italian Association of European Jurists, we have suggested to the Italian ministries to do exactly that, what Filippo was saying, to concentrate within the three courts, but we have had no answer so far. Any of the ministry we contacted.
What's happened in the United Kingdom is that after a long period of intransigence about the regulations, we now have rules to enable the transfer of cases that start in some distant court to the tribunal. And one of the courts of appeal has said, really, you need to do this, because to give you Scotland, there is the Court of Session in Edinburgh. There are 49 sheriff courts where you can bring cases, and the judge may not have a clue what you're talking about. So I really recommend, if you haven't got this sorted out in your procedural rules, do sort it out in your procedural rules. Now, we now reach the last lap, and this is very fascinating, because here we have the interaction of what's happening in data protection, where there's a separate association of data protection judges and our area. So over to you. This is going to be very fascinating.
Thank you. Do you hear me? Yes? Yes. Thank you, Mr. Chairman. And as the last speaker of this conference, I have the pleasure, this is a pleasure, to do a little step outside the box of competition law, to try to look at the problems that arise within digital markets from the perspective of data protection law, and with a view to verify if and to what extent action for damages under the GDPR may somehow contribute to address at least some of the problems that competition law enforcement is facing vis-à-vis unfair, illicit conduct of digital market operators, in particular those perpetrated through a violation of GDPR, so data protection law. And in order to do so, I will first very briefly recall the interactions between competition law and data protection law, and then move to analyze the remedies under the GDPR in terms of damage actions, and try to do a little comparison maybe with private antitrust enforcement. Having reached this point of the works of the conference, I don't think I need to spend any time to recall how important personal data are for digital markets. This has been done brilliantly yesterday already. Allow me to give you just a couple of examples where violations of data protection laws, the GDPR in particular, may also result, may result also in a violation of competition. The first example is the most typical one. So the collection and processing of personal data by digital platforms in a way that is non-complying with the GDPR provisions. And usually this processing by platforms needs to have a legal basis, and most of the times the only available legal basis for processing of personal data is consent. Really given specific, informed, and unambiguous consent of the data subject. Avoiding to request consent or giving to the consumer, to the user, inaccurate information on how the personal data are processed by the platform may give a competitive advantage to the operator vis-à-vis other operators who do the same business complying with the GDPR. This reading, and this has an effect also on the quality of the services that we are giving to consumers in terms of privacy compliance or the protection of their data, and may even have an even further consequence to induce other competitors to violate GDPR as well in order to compete. So we have a global detriment to the environment where these digital services are operating, a risk at least. This connection between violation competition law, and in particular, I'm talking about Article 102 TFEU, so abuse of dominant position, and violation of GDPR provisions, has been acknowledged by the Court of Justice of the European Union in a recent case. It's the Meta case of 4 July, decided judgment of 4 July 2023, says C25221. And it was a case arising out of the proceedings that the German Competition Authority had promoted against Meta platforms for the way in which Facebook and Meta process personal data and unfairly inform consumers on the processing. And in this occasion, the court expressly acknowledged that among the relevant circumstances of the case, that the compliance or non-compliance with the provisions of the GDPR may, among the relevant circumstances of the cases, be a vital clue to establish whether or not the conduct entails resorting to methods governing normal competition or not. And also, the court said that excluding the rules on protection of personal data from the legal framework, I'm quoting, to be taken into consideration by the competition authorities when examining abuse of dominant position would disregard the reality of this economic development. So whether it is convincing or not to deduct an abuse of dominant position from a violation of data protection law, this seems to be possible under new law, and it has been done by some national authorities at least. I should say, well, my feeling is a little bit that we are in search of any violation that allows us to prosecute these operators and somehow limit their power in the market. But aside from this consideration, I should also mention that the same conduct that Meta is having in this judgment has been subject to investigation by the Italian competition authority, but under a different set of rules, and in particular consumer protection rules and unfair practices directive in particular. So this is just to say that probably competition law is not the only set of rules to address this problem. We have several other set of rules available, at least to consumers. Another example I wanted to make is the violation of data portability rights. This is a right provided by Article 20 of GDPR, and it is instrumental, as we all know, to allow the consumer to switch from one provider to the other in the provision of the data-intensive services, I would say. So, in other words, the data subject has a right to obtain a copy of its personal data as detained by the controller in a structured, common, and machine-readable form, so that when it switches operator, think a telecommunication operator, a banking operator, it doesn't lose his history, his data. So here it's quite intuitive, the effect of a violation of portability rights vis-a-vis the competition of other operators. It looks very much like an excluding conduct to deny access to data. And here, an interesting example comes again from Italian practice. It is a case that our competition authority opened in 2022 against Google for denial by Google to provide an adequate interface to access personal data, in particular by WePol. WePol is an application, not directly by the data subject, but also in case. WePol is an application that works as an intermediary between the data subjects and businesses, and has the purpose to collect the data that are present in the web from different operators and store them, and then allow the data subject to monetize the use of their data in case some commercial operator is interested to use this data. So somehow it's a bank for the data, and then the WePol operates as a trader of the personal data upon consent, of course, of the data subject. So leaving aside the theoretical problem of whether it is allowed under general principle of law to trade or subject personal data as an economic value or to monetize them, but leaving this aside for a moment, it is quite clear that failure of Google to provide WePol access to data prevents WePol to even gain any kind of market share in the services and competing with other big data aggregators. By the way, the investigation was closed through a commitment decision, as it often happens in these cases where it is not so clear or easy to establish a violation of competition law under Article 102 TFEU, and this has consequences on private enforcement, as Luca very well already explained. So having thus established that sometimes a violation of personal data may result, if we accept that, in a violation of Article 102, then we apply all the private enforcement tools that we all know, with all the problems that we already discussed. Somehow, allow me just to do two quick remarks on this. So the issue of commitment decision, which is the most popular, let's say, ending of these cases, with all the consequences on burden of proof on the consumers, and the fact that as regard consumers, trying to envisage when a pecuniary damage can actually be claimed. This is probably possible in cases like the WePol one, because it's a loss of profit due to the impossibility to monetize own data due to lack of data portability rights. Maybe it would be possible also in cases in which a violation of personal data also brings the controller to apply, I don't know, discriminatory prices to different consumers. But out of these quite special cases, I would say, an abuse of dominant position with violation of personal data would bring a rather non-pecuniary damage to the consumer, which is not usually the damage one claims through an antitrust case. And this is why we can now turn to the second part of my presentation. So the remedies available under GDPR for damages of non-pecuniary damages to data subjects. Well, let me start with a general note on the way in which GDPR can be enforced. We have public enforcement from data protection authorities, and this can regard any type of violations of GDPR. And then there are provisions related to private enforcement. Article 79 GDPR provides for a right to effective judicial remedy of data subjects for any violation of GDPR impacting on the rights of data subjects. So probably not all the violations of GDPR give rise to a right to a judicial remedy. And then we have Article 82 GDPR, according to which any person, and I quote, who has suffered material or material damage as a result of an infringement of the regulations shall have the right to receive compensation from the controller or the processor for the damage suffered. And here, there are three elements of this action that I would like to focus on. The first one is the legal standing, the eligibility for damages. It seems to me quite clear from a systematic reading of GDPR that legitimation is only for data subjects and not for competitors. However, I have also to record that the different views are present in the literature on this issue, and they are based also on the wording of Article 82, because actually it says any person who has suffered material or non-material damage. In any person, we could in principle include a competitor who has suffered the damage from this abusive conduct. However, as I said, the same article makes reference expressly to compensation for the data subject in the fourth paragraph. And then there are other decisions in the regulation that I cannot analyze today that seem to move towards a more restrictive approach as regards eligibility. This is without prejudice, however, to the possibility to for competitors to have a claim for unfair commercial practices under national law, provided that this is provided under national law. This is also mentioned as a possibility under Directive 2005/29 concerning unfair business to consumer commercial practices, which at Article 11 expressly recognizes competitors as having a legitimate interest to combat unfair commercial practices. So in my view, this is a different cause of action, but probably the result would be to have a damage action also for competitors, provided the national also allows. The nature of liability, it's probably a strict liability test. Is it because paragraph 3, article 2 says that a processor or controller can exempt from liability only if it proves that it is not in any way responsible for the event giving rise to the damage. Does this refers to lack of negligence? Is proving lack of negligence enough to exempt from liability? Or is this clause referring to a general exceptional circumstances clause where outside the control of the controller. I tend to support the second and more restrictive approach, but this issue is actually pending before the Court of Justice for decision. It's a pending case, and I will give you references at the end of the presentation. And finally, the natural damage. Well, it's quite clear that we have both pecuniary and non-pecuniary damage covered by this provision. Coming to the issue of non-pecuniary damages, however, we know that these damages are subject to very different assessment in different jurisdictions in light of the culture also of legal culture of each jurisdiction. And for example, in several jurisdictions, courts tend to impose a gravity test, a gravity threshold, in order to acknowledge non-pecuniary damages. And this happens also in the Italian legal order. The Court of Cassation also in some recent judgments expressly set this test. So non-pecuniary damages can only be asked if a certain threshold of damage is demonstrated. The issue has been tackled expressly by the Court of Justice again in a recent case Österreich Post case, decided on the 4th of May this year, a case C321. It was a case relating to the collection of personal data by Österreich Post, relating to political orientations of consumers or users, which were elaborated through an algorithm and then traded to other businesses who needed this data for their commercial purposes. In the case, however, the data subject did not have any specific damage following this type of processing, but it simply felt offended by the fact that the controller had elaborated and stored its data on political orientation without its consent, and especially it had connected its identity to a specific Austrian party, and this was very offending for the person. So the question to the preliminary question to the Court of Justice regarded whether a simple GDPR infringement was sufficient for an individual to ask the damages to the controller. The second question referred to the availability of gravity test under national law and whether this is compatible with Article 82 GDPR. And finally, there was a question on the quantification of damages. The first issue was solved by the court by stating that a mere infringement of GDPR is not sufficient to ask damages because the data subject needs to prove the existence of a damage. Of course, this makes a lot of sense, not only of a damage, but also of causation and of infringement. Coming to the second point, the court decided that Article 82 GDPR precludes a national rule or practice which makes compensation for non-material damage subject to a certain degree of seriousness. And this is because, according to the court, making compensation subject to a certain degree of seriousness would risk undermining, I'm quoting, the coherence of the rules established by the GDPR, since the graduations of such threshold would be liable to fluctuate according to the assessment of the courts seized. So it seems a sort of uniform application argument adopted by the court, which actually put the Italian case in a difficult position, because apparently our Court of Cassation is not deciding correctly its cases according to the GDPR, and not only our Court of Cassation, but also other courts in other jurisdictions. To me, the uniform application argument is valid, of course, under EU law, but I'm not sure that this would prevent a different type of application in the different member states. I think that one of the most problematic issues which has come up, if I'm not wrong, also in UK courts, is whether the loss of control over personal data is already per se a damage or needs some additional consequence, such as theft of identity or whatever can follow from a loss of control over personal data. And this is very much, to me, the core point that will determine whether these actions will be actually useful or not in case of GDPR violations such as the one we are talking about. In Lloyds versus Google, it was a UK court, it was denied that loss of control would allow damages under the DPA list. Maybe it was possible under other cause of actions, but not under the DPA. And here, some guidance could come from Recital 85 GDPR, which refers to a totally different issue, but seems to list the type of damages that could follow from a GDPR violation, and loss of control is among them. I'm not sure this is actually very, like, the only way to read it. The recital refers to another issue, so in particular the notification of data breaches. So we will see how this will be decided by national courts. Certainly recognizes that loss of control over personal data is enough to ask damages would be an important step to ease the enforcement of data protection rules. Therefore, like data protection lawyers may actually be willing that the court will say that loss of control is enough, and that is already a damage in itself. Some of these issues, some of the questions I've raised are actually going probably to be answered by the Court of Justice soon. There are a couple of cases that you see in the slides where inter alia it was asked to the court whether acting anxiety is sufficient to damage and whether controller's liability in case of hacker attack can be exempted if the controller proves that he has adopted all the security and organizational measures to avoid hacker attacks. But this, we will see how the court decides this. So coming to my conclusions, there are a lot of legal issues still open. Probably damages action under GDPR will contribute to reinforce the GDPR enforcement and therefore indirectly to have a deterrent effect towards those unfair practices that affect the competitive process in the digital markets. It is not a chance that the GDPR was the first legal act adopted since the Commission decided to take action in terms of regulating digital markets. So the first step was the GDPR, and then DMA followed, the DSA, Data Act, Data Governance Act. So this is the ecosystem of rules that we can rely upon in order to regulate digital markets. But indeed, the GDPR is the somehow foundation of this construction, it seems to me. Yet there are some problems, or at least limits to the enforcement of GDPR. First of all, and the main one that I see is the fact that these kind of claims are small claims. So their deterrent effect is jeopardized if we don't access to collective actions in the EU legal order. And EU institutions seems to be very aware of this, as Directive 1828 of 2020 on representative actions for protection of collective interests of consumers expressly provides for an obligation of the member states to introduce legislation allowing collective actions from consumers for inter alia GDPR violations, together with a series of other legal norms already existing under consumer law mainly. rather, competition law is not included.
Not included.
It's
I
not
know.
included. And
It's the defendant lawyers.
yes. And so I think we also have to raise an issue of necessity needed here, because of course, when we have parallel actions, and if we will have parallel actions, we will have to tackle these issues as well. But I think now several other legal issues remain open, also with collective actions, which we will discuss maybe in another conference. Thank you.
I'm enormously grateful to you for coming back to collective actions, because in my career, this has really worried me when we've seen infringements where the damage to individuals is too small to bring an individual action. To give you an example, I did a case on motor insurance and price fixing with the car hire industry. The decision was so awful and revealed so much that was bad that it was the authority who asked us to quash the decision. And I was sitting with a judge who was inexperienced in public law, and John turned to me and said, "What do we do now?" I said, "We're seized of the matter. There's clearly bad behavior here. There's no doubt that there's infringement. That the remedy against which the industry was appealing was, if you're going to have price fixing, it should be done by an independent person, and they regarded that as hopelessly intervening in their business freedoms. The respondent had asked us to quash the decision, so we quashed the decision, and we took an undertaking that they would go ahead and reinvestigate. The Court of Appeal then, in a different case, said that the tribunal could not supervise the authority once we were functus, once we had given our judgment. So we didn't hold them to the time limit that I had set in the undertaking. It took them a mere 10 years. When they had investigated for 10 years, they said that it would be disproportionate to take action because the individual effect on those who insured their cars for motoring was insufficiently great to act. Collective actions and the threat of collective actions should be the leverage about that. Now, I have to thank our speakers. I have to get you to lunch. I have to say two other things. The first is that research is going on at the university at which I taught for many years, St. Andrews, on what is going on in the political damage to citizens of these algorithms. Algorithms that tune the systems to feeding us with the views we already hold in politics and do not feed us with contrary views. And I think there's real problem for the future of our democracies in the way in which this is working. The games that are being played, I have been taking seriously for some time, and when we met as an association in Vienna, I was in big trouble with a judge of the Bundesgerichtshof, who can remain nameless, who couldn't understand why I had allowed two people, one from the Bundeskartellamt and the other from the UK CMA, to play a game in front of us to demonstrate how Facebook works. He couldn't understand, why were we having a game? And I tried to explain to him, because you need to understand what's going on. But enough of that. I need to thank those who are involved in the project for delivering these 2 days. I need to thank those, particularly Luca, but all those who have spoken. I need to thank those who have chaired. I need to thank those who have come and participated. And I need to send you forth to go home, influence the way in which your courts proceed, influence the way in which your courts practice, and let's hope that we can make the national courts a real contributor to making our digital society a better society. Thank you all very much indeed. There is lunch.
Sorry, just one thing. There is also, for those who wish, the afternoon session, which will be held in Italian, but with the translation. So if your playing is not too early in the afternoon, if you wish, you can join us also for the afternoon. Thank you.
Very much.
Sorry to interrupt.
No, it was useful for enriching.
Quelle slide non le puoi formulare.
No.
Congratulations at the chairman and at my colleague.
Thank you very much.
You have to tell me what the tie is.
Pardon?
What is the tie?
Is from London, in Piccadilly Street, is do you remember the name of Covington, something like that? I don't remember. Is a shop for hunters.
Oh, right.
Shop for hunters. Is,
But mine is the edition Malaysia.
I have the one of the Korean
Right,
in Seoul. I was there. Adam, I noted that you mentioned a difference that you are doing in England, in the UK, between settlement decision and ordinary ones. If you give, do you have an email?
I do. No. Let me.
If you write me down,
Yeah.
I would be very interested to see if you have any documents, material concerning this difference, because in detail.
We don't have document details that differ because we haven't yet considered the effect of a non-settlement decision.
Because in detail, the discussion that we will have in January before the Court of Cassation concern the settlement decisions, and therefore I would be very interested to anything that you can have in this respect.
Yeah.
Thank you very
Send me an email. So
I'll send it.
But it's a point in English procedural principle.
English procedural. No, our point is settlement decisions don't have the same guarantees for defense. And therefore cannot have binding nature.
No, it's
If you have any material.
yeah.
Avevo bisogno di registrare la sua presenza. Ieri non c'era, vero?
No,
Dovrebbe inserire nome,
non
cognome.
per i crediti.
No.
Non c'entra.
Anche sulla presenza.
Io non sono interessato. Sfortunatamente.
I loghi, richiedere a tutti quelli che sono intervenuti di andarci con l'olio di autorizzare i loghi.
C'è il mio nome, poi cosa abbiamo?
Italia.
La mia sperma. E Raffaele.
Sì, si conta su a parlare, quindi.
Contento? Perché proprio detto
The exception by contract whether then that is regarded as a legitimate way for the purposes of the contract. Now there are formalities that we have recently changed up. So now there
Nessun ti aiuta questo.
no longer registered. Committed by canon law, civil. And there is a fine. Area of the registration, essentially the borough registration, the elect, they were not forwarding the church. Central computer. So it was thought and they were not married. And suddenly all the clergy were summoned and they parachuted in a new superintendent registry to resolve this terrible issue. There were all these people. They'd gone through the marriage, they'd seen the marriage registry, they had a marriage certificate, but it was not recognized by the state because it wasn't on the that would be very soon. Now it's immigration. I can be in prison if I get it wrong. We have two clergy in prison. Mainly to deal with the indirect marriage. If I marry somebody.
Okay, so against illegal immigration.
Yes, now.
Yes.
I can.
If you want to do longer time, signature, I would be in the post for you.
Yes.
See that.
I fact we are using it. Buying back
Yeah, that's fine.
Yeah. Sì, sì, no. Sì, Everybody go. You need to learn about.